Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
As the agent for Peyton Ansley, John Milton, you are indicating to me that you're quite familiar with Peyton Ansley, John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley, John Milton, as written in all capital letters.
All right, and you understand for my purposes, though that language doesn't make any sense. So
No, I do not.
I understand? Okay, well, I'm telling you that. And so I am, until you disabuse me of the motion, or the notion, I am inclined to believe that you are both the agent and the person. So. And it's
I'm not a person, I am one of the people, thank you.
Okay, thank you.
Okay. Thank you there. Thank you. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Large and in charge, apparently, right here in your face. I have, use the decibel meter to record their hump day yell. We will do that. Thank you for the reminder. I was going to forget. I have so many other things we want to do today. Let's see. No. I have pages and pages of apps. What was it called again? It was some crazy name. Papa Murphy's, Grubhub, Decibel. DB meter? Is it just DB meter? No, that was a different one. Test. I mean, this one works, but what was the... Somebody tell me the name of the app. I cannot find it. Recently added. Oh, NIOSH SLM. What a great name. It just rolls off the tongue. NIOSH SLM. Okay, we've got the app set. It's going. I'm already up to 76, which means bad news for your ears, good news for us in general. I have no idea who won the internet. I was doing other things. And I apologize, but I'm super excited about some of the other things I was doing. Somebody fess up. Wegob, you owned up first. You might be lying. I don't know, but apparently you're not. You've got somebody supporting you. Wegob, I doubted you. Congratulations. The internet is all yours. Keep it running for us. It's gonna be. We say the whole name. Says Redpen. Regobs it e. Regobs it e. I think. I don't know. I'm so bad at pronunciations. It's there's a break. 3 words. Okay. Regob's height. Got it. Thank you. Regob's height. Nailed it. First try. All right. Here's what we have. We have this camera right now because I have to tell you, I got my camera working, and this is a good and a bad thing. I want to take you back just a little bit, way back to yesterday. By the way, keep the internet running. Congratulations, it's all yours. Your sentence to internet ownership. It's all official. It's on the record. Everything else. Get your certificate, and it's suitable for framing. All that stuff, you know. Now on to the really exciting stuff that involves lots of cables. The internet does as well. But I'm going to show you a freeze frame from yesterday's previous camera. You guys remember this view? It's pretty good, right? It was pretty good. There's me looking off the screen. I was wearing yesterday's shirt, which is not the same color I'm wearing today, just for the record. Then I updated my camera to this right here. And I can see everything. And I haven't even messed with the settings much at all. But it is crystal clear. It is beautiful. It's almost too clear. I've had to clean up extra things in my room because everything just shows up. And the lighting's funky. Last night when I was playing with it, it looked in the dark because I was playing with low light. Everyone, when you get a camera, you play with it in the dark, right? Tell me, everyone who has a camera, that's the first thing you do. It's like, I wonder what it does in the dark. Last night it does this in the dark. It just grabs the light and sucks it in, and it's beautiful. Oh my goodness, I almost want to black out all my windows just so it's dark all the time. But I'm super excited, and I ordered another cable last night. It was the last thing I did last night. Close to midnight was on finding another cable. Apparently, the smaller the cable, the more expensive it is. And so I need not one. I already bought one, and it was nice and pricey. It's probably the most expensive. It is the most expensive short cable I've ever purchased. It's even more expensive than Apple dongles. Anyway, I needed two of them because one of them gets the video out, and the other one is how I control remotely this camera from my switcher. And so yeah, fun stuff. I'm super excited about this, but it shows that I've got like all my split ends on my long wavy hair, my luscious locks that I'm trying to hide. One day I hope to compete with the greats. I'm talking Peter Tragos and Ian Runkle. Today is not that day. So yeah. Anyway, today is not that day, but today is another day, and specifically, it is this day.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. 111 was the peak. 111 for the hump day. But anyway, it's welcome. We made it halfway through the work week. I saw 111 as well. Hey, I got a half thumb up. 1.5. Love you. All right. Anyway, we're excited. We've got my window just broke. That's because I have perfect pitch in my head. When it comes out, it doesn't sound the same, but when I hear it, it's perfect. Do I need a lozenge now? I was going to go with a liquid lozenge, if that's all right. I've got one right here. Soothes the throat beautifully. Let's see. Let's do birthdays. Now that we've ruined our voices for the week, let's do the birthday songs, and then we can begin. I want to talk a little bit about Brian Kohberger. That's where we left off yesterday, and that's did you register? I don't know how to do it. It didn't save anything. Oh, I see. I should have hit the play button, apparently. Next week. There's always next week. We'll try it again. I'm never going to remember what the app is next week, though, because that's a terrible name for an app, in case anyone wants to know. Oh, man. Amazing little meme from Thomas this morning. Let's see if I can show you this. Let's see if the camera will pick it up. Ready? I need to put do not disturb on in case somebody texts me. I don't want to give away people's numbers. Here we go. Oh man, I've got the focus set too far out. It's out here. We'll do it this way. Ready? Camera 1, autofocus on, boom. The last thing you see when your parachute fails, the ground coming. I think it's called cumin, but there it is. That was a little bit of funny this morning. Thank you for that, Weather Watch. Appreciate that. All right, where are we now? Birthday songs. Birthday songs first, which I guess I've turned the buffer sound off. Let me turn that back on. See if there are any birthdays. I know there's at least one. Ian covered the disciplinary board video last night. Don't know if you saw. I only saw part of his. I was busy shopping for cables. I did jump in and say hi briefly, but I didn't get to see. I'm glad he got to cover. I'll have to go back and watch because I'm sure that was pretty good. Let's see. So I've got this one, but where's the other one? Let's see if there's another. Is there another? There it is. This is the latest and greatest. All right, we have a few people celebrating their birthdays today, and we would like to celebrate. Sweet and Salty. I think this is the second day it's been your birthday. but it's okay. Porsche or Porsche. We're going to say Porsche because it has a look at this. Look at this. We've got like pronunciation guides and explanations for everyone. So we've got sweet and salty, 1111, Porsche, Stefan, and Willow, who was born yesterday. Or I guess Willow is pronounced born yesterday. I think that's how it works. So we're going to sing to these 4 wonderful people. Oh, wait, plus Selena and Aunt Lori. Sorry, that makes 6. 1, 2, 3, 4, 5, 6. Yep, math is good. And we're going to get this out of the way and then start beginning some of the craziness that is happening in our courts today. We'll do it like this. Everyone stand up, take a deep breath, shoulders back. There we go. Project your voice to the back of the room. Blend your voice with the neighbors. Warm up with me if you will. La 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 la. All right, we're good to go. Oh, we did it on the hump day yell though. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, sweet and salty Portia, Stefan, Willow, Selena, and Aunt Lori. Happy birthday to you. All the pronunciation guides messed me up. Stefan, did I get your name right? Did I call you Stephen? Lego husband, heavenly birthday today, Walter. Oh, happy birthday yesterday, or today, excuse me. Happy birthday, heavenly birthday to Walter. Lego, thank you very much for sharing that with us. Oh my goodness. The music just seems so loud in my ears this morning. Tracy Lynn George, what happened to me? Is it your birthday as well? Did you get in on the birthday list form? Yes. Tracy Lynn George, happy birthday to you as well. Let's sing the next one. This next verse is going to be just for Tracy Lynn. Got Stefan correct. Nice. Tracy Lynn, you get your own solo verse because we messed up. That's my fault. I apologize. Happy birthday to you. Happy birthday to you. Happy birthday, Tracy Lynn George. Happy birthday to you. There you go. Tracy Lynn, you've been sung to as well. Happy birthday to everyone who is celebrating a birthday today. I realize there are a million places you could be, a million people you could be with, and you've chosen to be here with us. The privilege and pleasure, the honor is ours. Hopefully we can return some of that to you and make your day a little more specialer. You can do that also by helping yourself to free pancakes at IHOP, Denny's, Village Inn, McDonald's, Waffle House, Andy's Grill. It's not Andy's Bar and Grill, it's just Andy's Grill, just for the record. Happy birthday. That drum solo is coming up, so everyone grab your drumsticks. Let's finish this off in a big style, big way, in 4K. We're not 4K here, but it's shooting 4K. Here we go. I'm going to knock over my drink. Beautiful. All right. That being said, we have... I want to jump right to a court that is just barely, I think it's actually still going on this very second. It's a quick little traffic court hearing, and I don't know what happened. All I know is that somebody broke character. And if you've ever been in the drama or, in the acting world, you know what breaking character means. And I wanted to see why. And so I have no idea what is about to come other than that somebody is going to break character in this video.
Let's bring in Miss Wingate.
So let's bring in Mr. Wingate. There we go.
This is case number 24RO08007. It is people of the City of Royal Oak versus Ethan Milo Wingate. That's you, sir?
Yes, sir. Good morning.
Mr. Wingate, you were present just a couple of minutes ago when the court explained the nature of an informal hearing. True?
Yes, sir.
And the court also explained that you must select from one of 3 options related to your own rights. Also true?
Yes, sir.
Mr. Wingate, the citation before the court was issued on October the 13th of this year at about 9:15 in the evening. You were operating a 2015 Charger white in color, 11 Mile Road, Eder near Campbell, in the city of Royal Oak. And at that place and time, you were displaying a tag that had expired on August the 10th.
Yes, sir.
related to your own rights, you may admit responsibility in this matter. You can admit with an explanation, or you can deny responsibility. We'll swear the parties and take testimony. What would you like the court to do?
I'm going to admit to it. The only explanation was I didn't get the form in the mail. So
Okay.
I had moved. So
Before we get to your explanation, you want to confirm to the court that you were operating a motor vehicle in the city of Royal Oak that place and time with an expired tag, correct?
correct.
Thank you. And I believe I just heard you say that you didn't get your renewal in the mail, correct?
Yes, sir.
All right, but you do have a registration today?
Yes, sir. I have it
Can
right here.
you display that to your device, please?
I don't know if you can.
Bring that in a little closer, say your name.
Can you see it?
Well, my eyes are never going to be able to see that because they're too old, but often I might be able to see it.
Yeah. I don't know.
It looks good, Your Honor.
All right.
I'd like to make a motion to dismiss.
There's a motion to dismiss, Mr. Wingett. Regardless of whether or not you get an invitation to do so, you're going to keep having these birthdays every August 10th. No, right?
Yes, sir. I know.
All right. You know what to do next time.
Keep a straight
Yes,
face.
sir.
Take care.
Thank you. Appreciate it.
He can't. I don't know what he said. What happened? The officer's like, take me off the screen.
Calling case number 24 RO07359. This is people of the City of Royal Oak versus Benjamin Thomas Friedman. That's you?
All right. All right.
Mr. Friedman, you were present, I believe, a couple minutes ago when the court explained the nature of an informal hearing. True?
True.
And at that time, the court also
Let's compose
explained that you'd
himself
be required to make a selection from one of three options related to your own rights, correct?
Yes.
Mr. Friedman, the citation before the court indicates that on 9/11 this year, at approximately 20 minutes of 10 in the evening, you were operating a 2013 Lincoln, black in color, on Main Street at or near Lincoln in the city of Royal Oak.
Lincoln on
with
Lincoln.
a tag that had expired on your birthday last July. You may, sir, admit responsibility in this matter. You can admit with an explanation, or you may deny responsibility. We'll swear the parties and take testimony. What would you like the court to do?
I would like to admit responsibility with an explanation, please.
Very well. So you were operating a motor vehicle in the city of Royal Oak with a expired tag, correct?
Correct.
And as for your explanation, what do you wish the court to know?
It was an honest mistake. You know, I've never had any traffic violations or any citations of this sort before. It just completely slipped my mind, and the next day I went and got my registration updated. So I have a copy of my updated registration here.
Okay, can you bring that into the device a little closer? Say your name, please.
Benjamin Thomas Friedman.
Thank you.
I see it, Your
Officer?
Honor. I'd like to make a motion to dismiss.
Motion to dismiss. You don't have an objection to that, do you, Mr. Friedman?
I do not.
Very well.
Officer is dying.
The matter is dismissed. You'll keep having those birthdays every July until you don't. You wouldn't happen to be a relation of the late and beloved Honorable Benjamin Friedman of the 45th District Court, would you?
No, but cool. Same name.
All right, then. You take care. Good luck to you.
Thank you. Thank you for your time.
All right. So that was that. We have a couple options. I wanted to finish Brian Kohberger. We have a Supreme Court hearing in the Karen Reed case going on, and because it's a Supreme Court hearing, I am very interested in it. Let's see if we can get because the case itself is going to be argued. It's the double jeopardy issue. It's the double jeopardy issue, which makes it quite intriguing. Let's put it that way. Let me see if I can get to. But I also want to finish Brian Kohberger. We're actually very close to having. Let's see. There we go. We're actually very close to having to finishing Brian Kohberger yesterday on the death penalty stuff. So we're going to come back to that. Let's see if we can jump in We're going to back up a little bit to the beginning and then speed catch up, if that works. Hang on one second. Sound effects help. They're very important. Speed 1.25. Okay.
Where the judge, basically there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error. Yes. That case is an opposite to what the situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declaration.
But that's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than in many cases where this court has remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think it's an extension of prior precedents. Fiddler talks about not establishing inflexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was.
Doesn't Fiddler caution to not inquire into the, to not to intrude into the sanctity of the deliberative process as well?
It does.
Absent this extraneous influence. But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
I would argue that it has to do with the results of those deliberations and that a carefully set of questions preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count one? How did you vote?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry, Judge.
You seek to impeach the written communication of the foreperson, correct?
I would say that the recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes, they related to a lack of unanimity, to a deadlock about charges. But count two by itself, read vertically, had multiple charges. Horizontally, there were three separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options to the declaration of mistrial. And I contest that there were at least three viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
You've got an exhausted jury writing this very eloquent message saying, we haven't been, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've reached verdicts on charges, or that this only relates to the second charge, right?
Facially, there was the words charges and the
audio sync is off.
What's going to happen with this motion for new trial, right? Everyone thinks the jury's done its best, it's exhausted, it's tried every option, and everyone's resigned to trying the case again. I understand something happens later, but at least at that point, is it really a mistrial? I mean, is it an error to declare a mistrial?
I would respectfully disagree that everybody concurred that there was only one reading of this note when the defense had no opportunity, despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Did the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
Once the judge discharged the jury, once the judge thanked them and said the case is over, the failure to make an objection was futile. It was unnecessary.
What about the case of Como
This is a beautiful courtroom.
Where the jury was sent, the jury goofed, essentially. There was a miscommunication between the clerk and, you know the case. The jury was discharged, sent into the jury room, and then we said it wasn't error to bring the jury back after discharge to clarify the verdict.
And Had the jurors that signed that or that made these representations starting the very day after the announcement of the mistrial, if they had told the judge?
I guess the point I'm asking Mr. Weinberg is there was a time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may, after the discharge of the jury, I'll talk to you later, as most judges do. The lawyers then talk about a scheduled conference and timing of it. Wasn't there an opportunity at that point for the attorney to object and say, this is what should happen, these are my thoughts?
There was an opportunity, but not a responsibility. The law in this case, starting 39 years ago with Stewart, places the heavy burden on the Commonwealth, which wants to re-prosecute a citizen in the face of the decision of the first jury, to recommend alternatives to the judge. And the trial judge found consent, in part based on the failure to make an objection.
And I think we cut you off when you said there were three things that could have happened. Can you please tell us what those are?
Yeah, one is the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said bring the jury in. The jury comes in seconds later, 30 seconds if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question and has no capacity to coerce, the jury into redeliberating. It would illuminate the implied ambiguity, which is illuminated by the jury declarations, that there were two ways to interpret the note.
Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes two previous notes reporting impasse? You argued very forcefully below that the jury had reached an impasse and for the Tui Rodriguez charge to be given.
Yes.
I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes, and there was no information intervening the second time you made that argument, no additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer asks...
I'm not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note, and the third note.
Yes.
That would indicate any less of an impasse between the first, second, and third notes.
Yes, what happened is that...
I'm just looking for a record site.
The record is the jury went out and deliberated for several hours, subject to a TUI instruction, which is designed to encourage a jury to reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would contend that all three notes are ambiguous. The defense...
That was not the argument you made below.
The argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there was no argument that these notes were ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was that there was ambiguity.
Not at the motion to dismiss, at the time.
They had no opportunity at the time.
First note, was there an argument made concerning ambiguity in response to the first note reporting impasse?
No, there was a request for TUI.
Was there any ambiguity argument made in response to the second note?
There was a request for TUI. But the only time that I suggest matters is the third note where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the three notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because before that, there's at least an impasse on one count, and there's no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Descasiano asked me for what the three alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts. The reporter's notes...
At the moment of the declaration of the mistrial, what suggested in the notes, the three notes, that there was any agreement as to any of the three charges?
Facially, they said they were at an impasse, and the court has an obligation to carefully consider all alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the Tui Rodriguez, and the prosecutor said, not yet. And she said, yes, not yet. And then there was the second note, where again they report that they're in an impasse, quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez, and the defense counsel says, yes, go ahead and give Tui Rodriguez, and she considers that alternative and gives the Tui Rodriguez instruction.
Yes.
Now we have the third note. We've really tried on all the charges. Some of us agree that beyond a reasonable doubt, the elements of each of the charges have been established. Some of us do not. And at that point, she's considered the alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time, it sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required. Because we don't know that the jury notes 1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict. If you want a mistrial, you ask for one.
So your rule would be that anytime there's more than 1 charge, the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask,
yes,
well, are you at an impasse as to count 1? Are you at an impasse as to count 2? As to count 3? That's the rule?
When there's a multiple count indictment, that's the rule as described by the reporter to 27B, which is a trial court must make that inquiry before ordering a mistrial.
I thought there was a may.
The may was in the rule. The reporter's note says must. I would argue the may relates to timing. In other words, there's no obligation of a judge at any particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in.
And in the ordinary case, the foreperson will say, we've got a verdict on counts 1 and 7, and we seal them, and then we continue on, and we can mistry the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples, but 27B preempts that in terms of the importance of a mistrial order.
And your argument to Justice Winwood, and I guess to me as well in the court, is that that is not discretionary.
My argument is that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates of Stewart and Taylor. Here they complied with neither one of them.
And that's absent any other evidence as far as the deliberations go in the notes that there's agreement, or at least partial agreement, on a particular verdict, correct?
Yes, those notes were subject to one of 2 interpretations, and given the obligation of a trial court to consider all alternatives, including the alternative post-Tui of seeing whether the jury wanted to deliberate on any one of the 3 counts, which is part of the statute. I think it's 268-34C. That's a third alternative. Here the problem is the record doesn't reflect the trial judge's consideration of these alternatives.
As a matter of fact, were there 3 separate verdict forms?
There was actually more than 3 verdict forms because the verdicts on count 2 had multiple, they had 3 different options.
Count 1 and 3, were there separate verdict forms for those?
I believe there were separate forms, but there was, guilty, not guilty, count 1, count 3, and count 2. There was supplemental instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, so I'd like to ask, the judge says she can't ask the questions that you're saying she could without interjecting herself into deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instruction given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors during deliberations. Can you tell us how?
Yes.
How would she do this? She doesn't envision a way that she could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, what the votes were. Just tell me what your thought process is on that.
My thought process, one, is that this court has the option of essentially informing the court what questions could be asked. And 2, if we're going to delegate...
Require follow-up questions. And unlike extraneous influences where you can say, okay, we only want to inquire about whether there was a racist statement made or something to that effect. This is different. We're going to have to require what their votes were and how solid they were. Isn't that going to get into deliberations, inevitably?
I think you could ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation, but I want to ask you the following questions. 1, did you take a vote on count 1? What was your vote? Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or rediscussed?
That question, was it final? Isn't that going to... The jury can change its mind, right?
Could, but there's no...
But isn't that going to result in asking that type of question? When you say final, if you don't get your way on 2, is it final?
Was it ever reconsidered? You know, my contention, based on these jury declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror who they served for months says to anybody, to the court, to the clerk, to the court officers, to the prosecutor, wait, I didn't agree.
They also don't write in saying we agree with the other 5 or anything to that effect. They're silent. As their deliberations are supposed to be silent, right?
But it's an almost unprecedented meeting of the burden of production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what Juror D says. We went to the bus and says no one's ever going to know that we voted to acquit.
Isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep saying that whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished. They weren't finalized. And you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser included. So what's your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Kafker's point, has called and said, hey, me too, we believe the same thing, for the court to say that this is what it meant for all time?
So, and the answer to the question, and I understand the question, in the Bluford case, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
But that's my point. If you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's change of position on count 1 and 3.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote that acquitted Miss Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the McCallop case, we allow a court to ask about mental processes. Was there communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important. Miss Reed was acquitted by those jurors, and we should have the opportunity, or not acquitted, we contend, a unanimous vote. We should have the opportunity to have Judge Cannoni conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with an external source.
Right, but when it's an extraneous source, then you need not get into deliberations. But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberations.
And I would contend they go to the results of the deliberations. They do not require a judge to ask, why did you vote not guilty? What led you to vote not guilty?
So the question asked to Juror F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended on how I would have voted on count 2. We were not yet done.
And that would reflect two things.
Jury deliberations, right?
That would reflect that the voir dire by the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are going to say to Judge Cannoni, if conducted, that was my vote, it was not guilty. We never reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to return a verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slips. And it seems to me, or at least please correct me, why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions? We have a long line of jurisprudence that says we presume that the jury follows the instructions.
Okay. And there is cases where, when mistakes are made by jurors, where they don't fill out the verdict slip accurately. The Capen case.
That's not this case, though.
No, this case, I think, is a stronger case for a voir dire because we're not impeaching a verdict. We're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity.
And before you shift back to that, what's the best case, best federal case? Because we're interpreting federal law here. What's the best, closest case, and not an extraneous influence case, allowing this type of probing after? If we want to go back and read one case that's going to do what you want us to do, what's the closest case?
It's actually a Mississippi case. I think it's named Martin versus State that the amici brief brought us to, where they read the newspaper.
It's a state court case, right?
Yes, it is.
Any federal cases? Because again, this is a federal constitutional issue.
You know, there are cases where jurors correct verdicts.
No federal case that has the. You're asking us to direct Judge Cannoni to do this. I just would be helpful if you have a federal example that we can turn to, because we're interpreting federal law, not our own law here.
Well, this court has a long history of applying federal constitution.
We don't have any cases except extraneous influence cases. I'm just looking, again, your chance. You do best case that we should look at for you.
You do have one example, which is the McCallop case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial bias.
Again, that's extraneous influence. That's different.
It's internal to, I think it's closer to the core of 606B.
No federal case we can turn to, for example.
Nor has the prosecutor come up with any case to the contrary. This showing by this jury, it's not going to open the floodgates for post-voir dire.
Well, that was my question. What's the limiting principle here? It sounds like if ever a juror comes back to the defendant and says, hey, that's not really what happened, then we open it up.
This would not be a case where a juror has second thoughts, is reconsidering, didn't think he or she was listened to in the jury room. These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty. And
so the jurors submitted affidavits?
The jurors would submit affidavits. If we asked the judge, if you're not going to accept the lawyers' affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyers' affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential appellate review depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedent to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules of Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B, or would have asked the judge to ask the jury whether...
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have 2 extremely experienced trial lawyers. No one in that room would ever think, potentially, a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving to Tui Rodriguez. And you say that there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table, is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
So let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer there's an impasse, bring the jury in. If Your Honors would accept the audio video that, again, the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised they weren't given an opportunity. They hear a door open. The jury could come in 5 seconds, much less 30, and I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections.
The judge said they're at an impasse, bring in the jury?
Bring in the jury, and you can actually hear a door open.
Okay, and you have 30 seconds to object.
But you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the jury.
You can say, Your Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was in the note.
But they did know that the jury had reported to her that they were at an impasse.
They were at an impasse. Bring the jury in. Yes, that was possible. But to ask to go to the bench. But this court,
and did that happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign. They want to re-prosecute somebody after a mistrial, to subject them to the perils of a second prosecution. The trial court did not impose a burden on the prosecutor. They have more of an obligation in double jeopardy law to raise options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial.
After a careful consideration of all alternatives and after giving the defense
an opportunity. Explain why, perhaps, the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted a verdict.
Mr. Weinberg, are you aware of any cases, or can you let me know if there are any cases where
there's no case
the judge gives TUI,
yep,
and then the jury comes back and says we're deadlocked, as articulate as this jury was or not, and then the judge does something different other than just declare mistrial?
Well, the statute itself says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I contest.
But here the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Yes. Right. And in the face of that, do you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect were carefully considered, including, is your deadlock on all three counts? Would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination post July 1, and I'm not arguing that that provides proof as to what the process was on July 1.
And the statute, again, is a may, correct?
The statute says, 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That, at minimum, was an option not considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, a number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she would have been aided by counsel. The law required she give counsel an opportunity to be heard. There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence of this court, and I contend it contradicts the core protections that double jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on 2 counts, one of which carries with it life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you.
Wow. Just because they were hard on him does not mean that's where they stand. They might be equally as hard on the state here. Oftentimes, Supreme Court justices will do this.
Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
They put it on the other
judge
sheet.
did inform counsel that the jury was at an impasse, and I would argue at this point it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given to E. Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, all the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the defendant did cause the victim's death. And it would have been a rejection of that defense and the defendant's public narrative. The defendant here did not want the judge to do more into it.
Rather than speculate what the defense wanted, let me ask you about what happened. Did the judge have either the discretion or an obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. Perhaps as a matter of...
Did the judge have the discretion to do so?
Rule 27B is discretionary. The language of the rule itself consistently refers to what a judge or a jury may do. I know the defendant argues...
So it's not inherently coercive?
Boom.
So if the judge has the discretion, it can't be coercive, correct?
Well, no, it's a matter of discretion, and then consider the factors that inform the exercise of that discretion, and that's what the judge did consider here. On the one hand, the judge had no doubt, based on the jury's notes, that they had not reached agreement on any of the charges. Further, the jury's third note had triggered 234A, 68C, so they couldn't be compelled to continue deliberating. They made it abundantly clear they did not consent.
Unless they want to.
Unless they wanted to, exactly. But indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It would be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argue against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits, now 4 or 5 days of deliberations. They've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impanelment process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why, when we talk about what potentially we could do short of saying, mistrial, let's start again?
Certainly, Your Honor, and I think, in hindsight, seeing, the quote-unquote remarkable turnaround of the defendant's position, would it have been better, would it have been preferable for the judge to take that extra step? Perhaps, and another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those 2 prior notes, I think the judge could reasonably conclude the jury is at an impasse, there is a manifest necessity for a mistrial, there is nothing more to be done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
You can't find consent, right? If you don't ask, the consent is out the window, isn't it?
I don't agree, Your Honor.
Really?
Consent through the lack of an objection here.
Even the burden of proof is on the Commonwealth. There's no opportunity whatsoever for the defense counsel to raise anything. I get you may have manifest necessity, but I don't see how you can get consent when they haven't been consulted in any way.
They were consulted in response to the first two notes. And what was the defendant's response to those notes? It was to argue in favor of due and thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from, that's different. I mean, they want a verdict. Because they want Tui Rodriguez doesn't mean they've consented to a mistrial.
Even so, Your Honor, they had opportunities to object. They could have objected while waiting for the jury to enter the room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's at an impasse. They could have brought the issue up again during the scheduling conference after the jury was excused to the jury room, and even after that, they still could have brought it up, and we cited in our brief Fuentes as an example of where a defendant lodged an objection after the fact, after the jury had been excused to the jury room, and at that point the judge did still consider counsel's arguments. And I think, given the defendant's response to the prior notes, it being clear what the defendant was advocating for here, and at the point of the third note, it being unavoidable based on manifest necessity to declare a mistrial, the absence of an objection here, or even asking to be heard, Your Honor, indicates consent.
You might have, I know it probably is in your brief, but what's your best case for that?
This case is closer to Pellegrin, Your Honor, and very different than Horrigan. Mm-hmm. So as between the two, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Horrigan is an example of that. Judge comes in, abruptly announces, trial judge is unable to preside, I'm declaring a mistrial. There was no indication there that the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared
How do you know the defendant is advocating for a mistrial as opposed to pushing a verdict?
Because, Your Honor, not just what they argue, but what they argue.
Because Tui, there's two results of Tui. It's either a verdict or it's a mistrial, and it pushes the jury to its extreme. So when you say that they're advocating for a mistrial, they could have been just as well advocating the jury for that final push. As the Tui Rodriguez instruction says, you need to check yourself. One side has the burden of proof. It's very favorable in some instances to a defendant. So how can you stand up here and say that they were pushing for a mistrial?
Perhaps as to just Tui Rodriguez, although as a practical matter, as Justice George has pointed out, experienced defense counsel understand that there's not going to be a mistrial before that instruction has been given, or very likely. But set that aside, Your Honor.
Well, I think experienced counsel know that you're most likely not going to get further deliberations. But also know that it could very well, it's a flip of a coin. It could be a verdict or it could be a mistrial.
Right. On top of that, Your Honor, I would point to, in response to the first note, the Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time. Let the jury continue to deliberate. Already at that point, the defendant was prepared to argue there's been due and thorough deliberation. I think the exact quote is, we believe there's been sufficient time. Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing that they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered. And the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a TUI instruction, correct?
Yes, they asked for that as well in response to both notes, Your Honor.
Do you need consent in order to win?
No, Your Honor. There was manifest necessity for the declaration of a mistrial here.
And so absent the consent, we can just, you think the manifest necessity existed?
Yes. I don't think that the judge abused her discretion in declaring a mistrial for manifest necessity based on the jury deadlock in this case for the reasons that we have discussed and were discussed with my brother.
But, counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in a record here where there, again, it's not necessarily prescriptive, but there's 27B that says may, there's other things that could have been done short of declaring a mistrial, is there could be an abuse of discretion because there's nothing to suggest that she went through the progression of what she could have done short of declaring a mistrial, which directly goes to not giving defense counsel an opportunity.
That would not be appropriate to conduct some sort of post-trial inquiry at this point for a number of reasons. One, this jury, a mistrial was declared, this jury was discharged, they've now been discharged for 4 months. They have no power or authority at this point to come back and render a de facto verdict.
Well, the request is to inquire of them, which we said you can do in Fiddler and McGowan et al., right?
But not to get into their deliberations.
Well, that's a separate matter. You said that you can't bring this jury back. You can bring them back for post-verdict inquiry.
Well, it's one.
under the guidance of Fiddler, et cetera, right?
It's one thing, Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury. It's quite another to bring a jury back to essentially construct a verdict that was never returned.
What Mr. Weinberg argues is what we protected are the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections.
This would be changing the law.
What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike...
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
It's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's, a balance of two competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
They have an interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it cannot be done in this case without getting into the substance of the deliberations, and I think my brother revealed that under questioning. There are several issues with it. One is, again, this jury has been discharged now for more than 4 months and has been subject to extraneous influences, potentially including harassment.
We've sent back jurors on race. I can't remember how many years. It was like a decade later or something. Timing's not going to be a winner for you, is it? It has to be.
No, that by itself, Your Honor, is not a reason not to do it. I'm raising it as an additional consideration or concern here. But there are others as well, which is it's not simply a matter of bringing a jury back and trying to ask them a yes or no question. That's not how juries reach verdicts. We ask them to engage in group decision-making, collective discussion, review of the evidence. So it's
our post-verdict inquiry is guided, and we always say to the jurors, and we tell the trial judges, you have to instruct the jurors, do not tell me about the contents of your deliberations, answer this specific limited question. And the limited question posed by the defense, and I think in the ACLU brief, is did you reach a verdict essentially on counts 1 and 3, or was it an acquittal? Right?
I don't know that was the specific question they proposed, but I understand. I take Your Honor's point.
However they phrase it, it's a limited yes/no question.
Yes, and my point is that's an artificial inquiry. Or take, for example,
have you reached a verdict? That in and of itself is a standard question, right? That can't be crossing the line, right? Or is it?
No, but again, I want to reemphasize the point that was raised earlier, which is imagine a juror had tentatively agreed to find not guilty on a particular charge. But that was subject to further deliberation or consideration. Maybe the juror wanted to see what happened with the other charges. You now bring the jurors back and you simply ask them, I don't want to hear anything else, I just want a yes or no. It doesn't give that juror any opportunity to explain that their agreement was tentative at that point. And so it's an artificial exercise to say...
Is that Justice George asked your brother counsel about Bluford? Is Bluford the answer for you that's what Chief Justice Roberts was saying in Bluford, that it's always tentative? Or is it's only in lesser includeds that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bluford. Is Bluford controlling? And it's the Supreme Court.
I would argue that it is, and I actually take it one step farther, which is not only is there the concern that was raised in Bluford that the perceived agreement or unanimity here may have been the product of a very early discussion subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say, you know what, I think the defendant is not guilty. So even if, like counsel wants to argue,
which is why we poll the jurors.
This was a final vote, this was a final decision, you still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
Can I ask, is their argument what Justice Sotomayor wrote in dissent in Bluford, or is the different?
To characterize counsel's argument, I think that they are relying on that for the notion of there being an acquittal in substance, not form, although if you look at the cases Justice Sotomayor cited for that proposition, they're all cases involving judicial rulings. They're not jury determinations. I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form, or I guess more to the point, says that a state cannot impose the requirement that a verdict be affirmed and recorded. I think, if anything, Bluford acknowledges that that could be a perfectly legitimate requirement. Where
this
it said,
is the state lawyer talking
the
about
defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment. So I think Bluford does support our case, Your Honor. I just do want to emphasize that it's not only just the possibility that there could be a change of mind during the deliberations itself, but even after that.
Is Bluford limited to lesser included, or is Bluford broader than a lesser included opinion?
I don't read it that way, Your Honor. No, I read it as the general proposition that there are multiple charges, whether they're lesser included or not. Jurors remain free to go back and revisit a prior vote. In fact, I think the court said that although Arkansas was an acquittal first jurisdiction, nonetheless the jury remained free to go back and revisit a prior vote because that's what jurors do, and it wasn't inconsistent with the instructions. I want to emphasize one other point, which is, at most, what we're talking about here with these juror statements is a snapshot of the jurors.
This is live mixtapes.
You cannot short circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants too. You could imagine a different scenario where a juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration. Unless Your Honors have any other questions, Commonwealth would ask that the defendant's petition be denied.
Okay, thank you very much.
Thank you.
Court, all rise, please.
I believe the way this is going to work is that they're done now. The Supreme Court, the drapes open, the justices file out. This is probably one of the most grueling.
Recess, please. Exit the courtroom.
Everyone go home. Get out. Okay. This is probably one of the most grueling experiences to experience as a lawyer, if from my vantage point. Watching lawyers step up and argue in front of 7 of the smartest legal minds in the state. Okay, that you don't become a Supreme Court justice because you did somebody a favor. Generally, Pickles, not politics, right? These are people who have years and years of trial court judicial experience, and are now sitting on the bench and have analyzed and studied and read and just they know the case. And as you get up and you start making your reading your appeal or making your argument in front of them, if they consent to hear the case, you get like 1 or 2 sentences in, and then all 7 of them just one after another just start attacking you, and they hit you with the hardest questions. They're generally no softballs, right? If you get a softball question, you're probably going to win. But let's see, somebody's calling in. Let's see who this is.
Call from Angela.
Angela, good morning. How are you doing?
Good morning. I'm doing good. Can you hear me?
I can hear you.
Oh, yeah, good. Okay. Well, wow, that was interesting. I think that it was very. Something is wrong on my end. Can I call you? Can I?
Yes.
End the call and call again.
Yes, I'll answer the next call. All right. It sounded great on our side. This was Karen Reed's appeal to the Supreme Court, saying, "Hey, that should have been not guilty on those 2 charges. The jury had a consensus. The judge messed up. She should have asked them what they thought, and that would have come out. Because right now, as it stands, the state is planning on re-prosecuting Karen Reed on all 3 charges, and 2 of which the jury said, according to Karen Reed.
Call from.
Hey, Angela, is that better?
Yeah, that's much better.
Okay.
Sorry about earlier. I heard you double, so yeah, that's why I needed to end it. That was interesting. I honestly don't know how this is going to end because, I mean, they did point out that there is no precedence for this to happen. But I believe that the defense was much more prepared. That might be just me. To answer judges' questions,
they were hit with more questions, and I would say harder questions, by the Supreme Court justices. Defense was than the state was. The state was sort of brief, but really, when your case is fairly solid, you don't need to argue a lot of extracurricular stuff. And there's no indicator. Just because the Supreme Court justices asked you really hard questions about your case, that doesn't mean that they're against you. As a matter of fact, they do that on both sides. That's how they work. Yes, this was state Supreme Court. This was not federal. Federal does not have cameras in it that we can sit down and watch. Yeah. But this is state Supreme Court as they're doing this. I don't know how long it's going to be before they release a decision. But eventually the justices will, after weighing this, they'll meet together privately, basically vote on this case. The outcome of the case will decide whether her appeal stands or not, and that would definitely impact could impact what happens going forward in her trial. And then they'll release those written statements. They'll release a written finding. So someone will write the consensus vote, and someone will write the dissenting opinion generally. And you'll get to see into what this is prime for a new decision because there is no case law. They don't have anything to fall back on that's in this situation. And really, even though they're asking a million different questions, the heart of the matter is how important or how inviolate is that individual's right to a fair trial and not have double jeopardy, not be tried twice for the same crime. I mean, how much weight do you put there? And this is going to be, I don't know, it's going to be pretty interesting. I don't know why you're buffering. I'm pushing 9 megabits per second, probably because my camera is a little higher definition than normal. Anyway,
I'm directly wired. My computer is directly wired to the high-speed internet, and you're not buffering. So it might be something individually. So yeah. I read the same comment. Well, I really hope that something changes. And I wrote in the comments earlier that, there is no case law, but here this is a unique case on so many levels because we have a clear corruption. It's not anymore hearsay or conspiracy theory. It's a clear as a day. And maybe even judges involved in the corruption one way or the other. Well, we all know which is the most high likely way. But let's not accuse anyone. So even if defense asks, I still think that she will no, I'm still gonna declare a mistrial and so on because I don't think she would, I think that Supreme Court needs to, even if they manage to kick it back or something, I think this is gonna end up some way even higher. Because this is gonna, even if they stand, it's gonna go up higher than this course, one way or the other. I think
it goes up to the federal Supreme Court. I think that's the only other place it can go, right?
I mean, it wouldn't surprise me.
Wow, it would be quite interesting if it does. Interesting. I loved listening to those arguments and hear them. I love watching very competent lawyers do their job, and in a very respectful way. We've seen courts where there are good lawyers that are very disrespectful to each other, and sometimes even the court. But listening to these lawyers refer to each other as brother, as is tradition in front of the Supreme Court. My brother said this, my brother said that. It was amazing. The case law they knew, the citation, the code, precedents as they were, rattling off different cases where they thought applied in their argument. Absolutely amazing. These are top lawyers at the best of their game. And just imagine having an argument with someone who's very, very smart on an issue. Okay, it can be very intimidating. Imagine you have 7 of them, and they're all grilling you at the same time. What a rush! What an intense experience. Crazy, Angela. Yeah,
I have one more thing to say. Not related to the Karen Reed case, but related to another case that we have followed, the Carly Gregg case. I told you you read my email about what case I chose, and yes. I went down that rabbit hole. And I read about the Miller hearing and the definition of the Miller hearing. Carly Gregg was 14 when she did what she did, and she got life without parole.
And just for a reminder, it's Carly Gregg. She's the 14-year-old girl that shot her mom, tried to shoot her stepdad. We followed that case here. Go ahead.
Yes. I Googled around a lot, and she got life without parole, and the judge did not do the Miller hearing. And according to Constitution, he had to do the Miller hearing.
Remind me what the Miller hearing's for.
Miller hearing, in order for an underage person to get the life without parole, a judge has to conduct a Miller hearing. And the state has to prove that the person charged deserves a life without parole.
So you think she has grounds for a new trial?
She might have. Very good.
Interesting.
It's a Supreme Court case. It's Alabama v. Miller, if anyone is interested to look it up.
Wow. Interesting. Well, thank you very much, Angela. Appreciate that. We're going to jump over to Brian Kohberger really quickly because we're going to finish up his "Please Don't Kill Me" argument. So thank you, Angela. Good talking to you.
Thank you. Bye-bye.
Bye. All right, yesterday we started reading through about 14 pages of a 143-page document. We stopped on page 14. I didn't realize it was only like 15 or 16 pages long, and the rest were all addendums and attachments. So last night, as I promised, I was reading through this to see how I could glean and pull out the important bits, and I realized we were almost done. So I do want to finish the Brian Kohberger filing reading. This is this motion. Hang on, let me just get to the top here. They titled it... Motion to strike state's notice of intent to seek death on grounds of means of execution. So the state says, hey, by the way, we're going for the death penalty. And the defense has now filed a motion saying, we want to strike that. We don't want them to go for the death penalty. And the motion itself has talked about the history of the death penalty in Idaho, all the way from hanging. It describes a hanging, the report. We've read reports of executions by a firing squad that happened in Utah, the only other state that has the firing squad as an execution method. We've gone through all these arguments as the defense is basically saying, look, Idaho, even if you wanted to, you can't kill him because you can't find any medical doctors, because the law says you need a qualified, medical doctor to administer these drugs. You can't find one who will go against their Hippocratic oath and kill somebody because they've got the whole do no harm oath that they've taken. Good luck. You're not finding any. You can't get the drugs because the manufacturers of the drugs are, protesting and won't sell you the drugs that they're using in the lethal injections. It just doesn't work. And you've got whole issues about whether it's, it's cruel and unusual and inhumane. So they say that's off the table. The firing squad also off the table because of previous rulings. Hey, Mrs. R.A., welcome. Did you want a book? Anyway, so we're finishing up with the talking about the firing squad, and let's pick up where we left off here in the state's motion. They say the original firing squad, however, never got off a shot. In 2009, the firing squad was repealed with a statement of purpose that read, actually, I read that one already. Do you need another book? Just whatever you do, don't bump my camera because I haven't locked it down yet. Do you need me to reach for it? You have to buy one. You're missing a book. That's like me missing a cable. It's like, well, I got to buy one. There's always another book. All right, let's see. Where are we at? Page 14. Okay, the Court of Common Pleas also found the firing squad to be cruel. Here, it is clear that the firing squad causes death by damaging the inmate's heart, his chest, including the heart and the surrounding bone and tissue. This is extremely painful unless the inmate is unconscious, which, according to doctors Ayden and Alvarez, is unlikely. Rather, the inmate is likely to be conscious for a minimum of 10 seconds after impact. Moreover, the length of the inmate's consciousness, and therefore his ability to sense pain, could even be extended if the ammunition does not fully incapacitate the heart. During this time, he will feel excruciating pain resulting from the gunshot wounds and broken bones. This pain will be exacerbated by any movement he makes, such as flinching or breathing. This constitutes torture, a possibly lingering death, and pain beyond that necessary for the mere extinguishment of death, making the punishment cruel. The Supreme Court of the South Carolina has now found that the firing squad is neither cruel nor unusual. It does so by separating the horrors of what was contemplating from what it calls the critical question, or as they put it, our definition of cruel does not call upon us to analyze what the death chamber looks like after the execution has been carried out. There's no consideration in our analysis of whether the method of execution is cruel of the dramatic imagery set forth in the Chief Justice's dissent, the circuit court's order, or the inmate's brief, such as blood soaked in an inmate's clothing, spattered on the walls, or pooling on the floor, or whether physical violence to the body that occurs simultaneous with or subsequent to the cessation of pain. While each of these might have been political concerns addressed by our General Assembly, they are not constitutional concerns. Our definition of cruel defines the critical question and requires us to focus on the risk of unnecessary and excessive conscious pain. Having thus turned death into a sort of parlor game, guess at how much pain one might experience after being shot in the heart, the court finds it is not convinced it sounds all that bad and thus cannot qualify as cruel. The only authority it relies upon are the various statements of liberal justices and judges dissenting in various cases. Given that the person chosen at random from the street can probably name a few pleasanter ways to die than being tied up, bagged, and shot, it is hard to see this opinion as anything more than a political stunt. In any case, the court's eventual decision to decide is not unusual, despite the fact that almost no one uses the firing squad except when chosen by the condemned, which they can do in Utah. To uphold its use in South Carolina, where the law only permits its use if chosen by the condemned, makes this opinion of no use to the state of Idaho. So disregard South Carolina. I guess they're also South Carolina, Utah. Who else has the firing squad? I thought it was just a couple. Idaho's statute authorizing the firing squad as punishment is excessive because death by firing squad subjects the human being killed to unnecessary physical pain. Even in the best circumstances, meaning accurate shots fired and hitting the intended target area, death is not immediate. Awareness continues and pain exists. Counsel for Mr. Kohberger has attached the article, The Possible Pain Experienced During Execution by Different Methods, by Harold Hillman. It quotes the Royal Commission on Capital Punishment, rejecting shooting as it does not possess even the first requisite of an efficient method, the certainty of causing immediate death. Dr. Barbara Wolf's affidavit also shows that shooting is cruel. Idaho's death penalty statute only permits unconstitutional or unavailable methods of death under the United States of Idaho constitutions, and this court should declare the law unconstitutional and strike the state's notice of intent to seek death penalty. There is no humane reason to place Mr. Kohberger into solitary, as described in his motion to strike state's notice of intent to seek death penalty on grounds of international law, with a promise to kill him just as soon as the people of Idaho can figure out a way that is available, humane, and does not cause a circus outside the prison. Thank you. Adramalama, Idaho, Mississippi, Oklahoma, South Carolina, and Utah, all with the death penalty, allowing the firing squad. Conclusion. Here's their conclusion. This is the big finish for Kohberger's defense. Based on the foregoing and argument to be presented at the hearing hereon, this court is respectfully requested to grant this motion that A, the state's notice of intent to seek death penalty be struck. So get rid of their motion to seek death penalty. B, the court seat a jury that is not death qualified. So don't make the death penalty, don't ask them the questions that would qualify them to be a death penalty qualified jury, so they can't reach that conclusion. That's pretty strong. C, the court preclude the admission of any evidence of aggravating circumstances during the trial of this case. Don't even tell them they're aggravating circumstances. And D, the court not instruct the jury on any aggravated punishment. They want 4 different ways to keep this from going to the death penalty. And then it's signed by J. Lodson, 1st District Public Defender, who was on Brian Kohberger's team. And then we've got 140 pages of supporting documents. So they are asking, and there will be a hearing that is heard tomorrow. They're asking for the state to, or the judge to throw out the death penalty option, to keep that off the table. And a lot of people might be listening to this as we're listening to the lawyers say, but it hurts. It hurts the defendant if you're going to execute them. The firing squad's painful. The lethal injection is painful. It doesn't always work properly. All these problems. And the commenter is like, I bet there are four college students that if they could testify, they would say that, yeah, it hurt us too, right? But that is not the measurement that is used here. Voice audio declined, apparently. I tried to take a call, but it didn't take. So this is not the only motion they have filed. Oh, they're calling back. Let's see.
Call from
Sim.
Sim or Sam? This is Scott.
Sim,
how are you doing?
S-I-M.
Welcome.
Oh, I'm doing okay.
What's on your mind?
I just want to comment on the whole, you need a doctor to administer the drugs. You don't. The being able to get them, all the drugs are common in day-to-day medical practice. It's just getting them for execution.
Yeah, it's the companies won't sell them to the states if they know they're using it for execution. Your audio in the background is causing a weird loop for us here.
Okay,
Sorry.
Here, let me close this. That's only if they say it's for execution. You cannot tell me that the state of Idaho does not have it for hospitals.
Oh, I'm sure. Other doctors can get all sorts of medications, and hospitals and pharmacies may stock this on the regular. But in the quantities and the amounts they use for execution, they may not ship to 666 Prison Road or whatever when you place an order.
But you can ship it to Idaho. Yeah.
I understand what you're saying. There are ways that the state should be able to find their way around this. In Idaho, the state law requires it to be a certified, competent, licensed medical doctor. That's the law's problem. They can change the law and get around it. I mean,
okay.
The average phlebotomist could probably make it happen.
MD or DO after their name.
Yeah.
They wouldn't even let a nurse do it, huh?
Yeah. They won't, but a quick change of the law could fix that, and their law is retroactive, so changing the law would apply to all the people who currently sit on death row. But so that's an option. What do you think about the firing squad?
Actually, I'm not really big on the firing squad because it's not quick enough. It's not painless enough.
10 seconds is what they say. 10 seconds.
Yeah. Well, I mean, that's what I'm saying. Lethal injection, you basically have them knocked out, and it's basically like general anesthetic. Like anybody who's ever had an operation, how much pain have they felt during the operation.
Okay, now that's an interesting point, because I want to bring up, I have a close acquaintance, possibly even family member, who went into for childbirth and had to have a C-section, and was given the typical medication for that process, and felt everything. That just didn't work. The drugs were administered properly, and they felt everything. Is that a risk?
What were they actually given? Well, were they given the knockout drugs, or were they just given a epidural?
They were given the knockout drugs and felt everything, and basically were paralyzed, felt everything.
That's interesting.
So,
because usually if you're properly knocked out, you're not going to feel it.
Yeah, that's the idea.
No,
that's why we pay the doctors big bucks, so we don't have to feel that. But.
Well, see, my dad was an anesthesiologist.
All right.
So, it's kind of, I have some vicarious knowledge of that, and it's,
Yeah.
Maybe they weren't, maybe the female you're talking about wasn't given enough.
Yeah.
And being in that, then again,
I can tell you that.
Are they looking for other indications that they are in pain?
Yeah. Like heart rate, things like that changes.
Yeah. Heart rate. Yeah.
Do you think that Idaho could make this happen? Or do you think that this appeal stands to, that this motion has any merit to it, or is this just a throw spaghetti at the wall?
I think it's a well, if they change the law about who can administer it, and I understand where the doctors come from, but you get a bunch of, former military medics that aren't under the constraints of like the doctors are, that have the knowledge to do this stuff. How to start an IV. Yeah. How to push a syringe. How to run an IV in. There are people out there that haven't made the Hippocratic Oath that have the knowledge on how to do it. Yeah. And I did a paper for my legal research thing on why there are so many botched executions this way. A lot of it comes up with people, they don't get a good intravenous access.
Yeah. They miss the vein or something. Yeah.
Yeah, basically they miss the vein, and then they're forcing the stuff in, and the potassium chloride, it does burn.
Yeah.
So.
Yeah, the description, it sounds pretty terrible. It sounds effective, but it sounds pretty terrible in reading this. Sim, thank you for your input and your insight as well, with the family connection. That's okay. Appreciate that. Good talking to you.
Nice talking to you. Just want to get some of that stuff straight, or at least other people thinking about it.
Yeah. I think changing the law would help them. Thank you very much, Sim. Appreciate the call. We'll see you. We have one more filing I want to read really quickly from Kohberger. Possibly, let's see, two. Let's see. Okay, they filed another supplemental request for discovery. This was filed a couple days ago, and this will also be handled in the hearing tomorrow, but possibly in the closed portion of the hearing. So we expect that to be broken up. The 18th supplemental request for discovery, it's going to be Exhibit O, and Exhibit O is going to be filed in person to the judge under seal. So there's something that defense wants that they don't want everyone else to know about. They also have one other motion, and this one's really short. This one's reply to state's objection to defendant's motion and memorandum in support of the motion to trifurcate. Whoa, trifurcate. This is going to be the new word of the day. Hang on one second. Hey, this is Scott. Who's on the phone?
Debbie.
Debbie, how are you doing?
Good. I just want to say something about C-sections.
Yeah.
You don't go under a general anesthesia with a C-section. You get an epidural. Epidurals can wear off. Once you're right in the middle of the whole shebang and the epidural wears off, that's it. They got to finish. So Once it wears off, that's it.
I'll
You're in trouble.
I'll have to go back and talk to my my relative and see what the facts were, because I understood it as being under general, and in a very alert, because she described conversations people were having and everything while she was apparently out and shouldn't have been aware and knew everything that happened. So I'll have to get the facts straight on that one. Then we can discuss that one.
The C-sections that I have seen have not been Sarah Not Boone said that she's had emergency C-sections, or that emergency C-sections are under general.
Mm-hmm.
I've never seen one done under general. I've seen emergency C-sections done where they were wide awake and with their husband right there with them and everything. So I've never seen one done under general. I've only seen them.
We've got people in chat saying I've had 4 C-sections done under general. So I guess there are some situations where it is done that way, but.
Oh, okay. Well, I've never seen one done under general, so maybe I'm wrong.
No worries. No worries. Debbie, thank you very much. Appreciate the call. Good to hear from you. We'll see you.
Okay. All right. Bye.
All right. This motion here in the title, it has the word of the day, which is trifurcate. 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 Definition of trifurcate means to divide into 3 branches or forks. So they're replying to the state's objection to the defense motion in support of a motion. Okay, this is like Inception level. To divide into 3 the proceedings and apply rules of evidence during the eligibility phase. Okay. Apparently they want to break up proceedings into 3 different parts, and let's see if this gives us any clue as to why. Comes now Brian Kohberger, by and through his attorneys of record, and submits the following reply to the state's objection on his motion in memorandum in support of motion to trifurcate the proceedings and apply the rules of evidence during the eligibility phase. Man, these headings get crazy. The state objects to the idea of dividing into 3, trifurcating, proceeding on the grounds that it is not contemplated by statute, difficult in practice, and objectionable in post-conviction proceedings. So that's the state's argument. As to the statutory scheme, nothing in the statute prevents trifurcation. As it states in the law, it is important for the court, or the rules, it is important for the court to decide how evidence should be presented to arrive at the truth. Mr. Kohberger argues that trifurcation would be helpful in that regard for various reasons he has argued. As to how difficult it is to do, Mr. Kohberger's attorney, Mr. Lodgson, was of counsel in Renfro and took part in the trifurcation in that case, which was not difficult. Whatever post-conviction counsel may think about how it was handled in that case, it certainly was not awkward or difficult to do, and the fact that various other jurisdictions Mr. Kohberger has already listed in his motion affirms that. Mr. Kohberger would note that the state's example of what may cause confusion, the propensity aggravator, is actually a good example of why that statutory aggravator ought to be struck entirely. Oh, this might be still another effort to go to get rid of the death penalty option. It is simply not the sort of aggravator that should exist in the eligibility phase. The real problem that this court has to grapple with is the hodgepodge death sentencing scheme Idaho has due to its transmission from judge as sentencer to jury as sentencer state. It is one thing to throw all this information at a trained lawyer and expect to get well-reasoned decision, and quite another to do it to 12 random bus stops. No, bus stops not in there. 12 citizens with no formal training. Add to this that the case law itself is on what aspects of the scheme should help the selection process as opposed to the sentencing process, and it can feel like too much to try to figure out how to provide jurors with a logical and understandable system. However, that is the job that must be done. To get there, Mr. Kohberger has not only requested a trifurcated trial, broken into 3 pieces. He has also pointed out that each of the statutory aggravators in this case have crippling flaws. Assuming this court determines that any of them survive scrutiny, a trifurcated proceeding is the only reasonable way to proceed. So this is, if we lose our motion, if we lose on the motion to throw out the death sentence, we'd like to divide the court into 3 times. We've seen the court bifurcate, where they say, okay, here we have the evidence section. This is the guilt phase. and here we have the penalty phase. So it sounds like, and I might need a lawyer to correct me if I'm wrong, it sounds like we want the guilt phase on the base charges, a guilt phase on the aggravating factors, and then a sentencing phase. Donnie, try again tomorrow, Donnie. I've got to, you know the rules, man. Okay. All right. This is a competing argument. It's one of those situations where you can't have it both ways, right? You can't have three sections to a trial and throughout the death penalty phase. It sounds like they want, if the one isn't granted, then the other, which is an interesting little idea. And I wonder if Judge was not huge on ruling from the bench when we were up in Latah County. Now that we're in Ada County, we might get a different situation entirely. So that could be interesting.
Call from.
Okay. All right.
To accept, press 1. To send a
We'll talk to you
voicemail,
tomorrow, Donnie. We'll talk to you tomorrow. That's all I'm going to say. You pushed it too far today. No phone calls today. You have to sit in the corner. Let's see. Trifurcate. We're done with that one. Let's see if there's anything else we wanted to bring up on let's see, Kohberger. Let's see, we've got a couple motions to amend caption of previously filed motion. That's just correcting something. Order to amend caption. Amended motion to strike state's notice and seek. Okay, we've got all that motion. Reply to objection to motion to trifurcate. Reply to the state's objection to motion to strike. Arbitrariness. Trying to see what all is going to be brought up. There are, since just on the 24th alone, in the Brian Kohberger case, there was 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 15 or 16 different motions filed with the court. There's a lot that we might cover. It might be a full day hearing tomorrow. Or it might be, a pretty lengthy one, but lots of replies were filed on things from expert testimony from witnesses, aggravating evidence, means of execution, international law, utter disregard aggravators. There's a ton. The trifurcation. There's a lot that the judge has to sort out. Okay. In chat, hey, let's not comment on the mods or my decisions on moderation. We do that on the back end. Let's stay focused in court. There were a couple things I wanted to jump to. The disciplinary board, which is one we watched yesterday, is going to return shortly. They have a case before them right now of a lawyer who appears to have been set in the naughty corner because of a drug addiction, a heroin addiction. Lost his bar license, and he's trying to get reinstated now. So he's got evidence. It might even be a 2-day hearing as they hear why they should allow him back. That has started this morning already. Let me see if I can go back and watch some of it. Let's see here. Nope, that's not it. Although Peter Tragos is there. Nope, it will not let me go back. There's no replay. They are brutal. They are brutal. Fine, I'll record it. So we'll watch for anything that happens there. Let's see what else is happening in the world of courts. Yeah, but overcoming a heroin addiction. First of all, that is awesome. That is that takes a lot of work. An addiction of that type is incredibly difficult to to recover from. So I'm looking forward to hearing a little bit about that one. Let's see what happens here. I think we have another court for, I think Judge Simpson is live. Not sure why this is not recording properly. Have to test. Oh, I know why. Because it's full. Huh. I need to delete a bunch of video. And when this screen right over here, the left side of the screen is one hard drive that's 2 terabytes wide, and the right side of the screen goes over here that you can't see is the other hard drive, which is completely empty, but I'm recording to the full one. So my recorder is like, when I hit the record button, it goes in this like panicky, flashy mode where it's like, ah, and like that. It's, it's flashing 1 billion times a second, saying, help, we're running out of space. So I need to make some room for it. Hopefully this will fix it. So that's on the original big deal. Here goes up. See how much room I just made? Just made a ton of space. Hello?
Good day. Yes, hi, good day, Dwayne, Bones. Hi, this is Jennifer from Your Choice Getaways, and I'm calling about large amounts of a travel credits you have in your plan. And I see the activation fees were covered. You just never book dates and travel. So we don't want to see you lose the credits or the vacation themselves. I know that you still see yourself traveling in the future, right?
I do. I have a hard time choosing. There are so many options sometimes, so I need some help that way.
Yeah.
But yes.
So you don't have to worry for that, sir, because this is a lifetime to travel. And this package for you is customizable, so you can choose whenever you want to go here. So let me go over what you have here, Mr. Dwayne. So, Mr. Dwayne, you have your 5 days, 4 nights resort stay in Vegas, on or off the trip, and it's second gift. You have your 5 days, 4 nights resort stay in Orlando, minutes from all the theme parks. And you also have your 8 days, 7 nights all-inclusive flex cruise with Royal Caribbean, Norwegian Cruise Line. And now all is the remaining are the original booking and processing fees. I know that I can do something really special for you. Give me a moment to pull up your fall account here, all right?
Okay.
Just stay on the line for a moment here.
Hi, thank you for holding. My name is Samantha. You just got transferred over to me so I could further assist you. Hi, how are you?
Hi, Samantha.
How are you doing today?
Not too bad. How about yourself?
Here, I'm doing well. Thanks for asking. So my job is just to go over the details with you and answer any kind of questions you might have about the vacations. How many people normally travel with you?
I like large groups because it's like I'm not claustrophobic. I like to be around a lot of people, and if I'm by myself, I get really nervous.
Okay, I'm the totally opposite. Okay, so I mean, on this package here, you can bring up to 5 travelers on most of your vacations. We do give you an 8-day, 7-night condo stay with this that could be used for more than 5 travelers. If you want to bring more than that.
Like I'd like to bring think really large family reunion type size. I'd like to organize something big. Oh my goodness. Why, Samantha? Samantha, I was going to get to just 769 of my closest friends. Oh, Samantha. Not our Samantha that we love. This was a different Samantha, by the way. Bummer. When are we going on vacation? What did I say? I was not overexcited about anything. I was going to ask if we could get a cruise trip that involved a NASCAR race. If we could put that into a package deal, then I would sign up for sure. All right. Oh, we're back.
And describe your background and your education and how you ended up in drug court. In 30 seconds or less.
Well, naturally, I graduated from high school. I went to University of Pittsburgh undergraduate with the intention of going to medical school. I did all my required subjects for medical school within 2 years, and then I decided I didn't want to be a doctor. Changed my major and done it. If you ask me why, I probably couldn't tell you why. But at that time, I decided going to English literature. Now, why? I have no idea. But I did, and graduated from the University of Pittsburgh in 1965. I went to Temple University School of Law from 1965 through 1968. I somehow lucked out and made law review, and I had interviews to remain in Philadelphia. My wife and I worked with, you probably remember, there was a company called Ship and Shore. It was a clothing company, and they were looking for a counsel, and where my wife worked, she knew the guy, and he wanted me to come. Anyway, I said, no, I wanted to come back to my hometown, Mason.
And Masontown's in Fayette County.
It is.
So when you came back into Masontown, you passed the bar and were licensed as an attorney.
Yes.
And what did you do? How did you get to the court?
I've got another spam call.
Waiting for my.
Hello? Hello? Hello?
News that I passed the bar, there was a vacancy, and I was appointed as assistant public defender, assistant district attorney. And I did that until I became the first assistant. And then a client I had who was in a very nasty divorce, his wife left him after he was a coal miner. He worked all his life to save up to buy a home, and finally bought a home. And his wife was seeing another person, a doctor in town. And although he claimed innocence, and I believed him since he was my client, he shot and killed the doctor, went to prison. I had retired from the district attorney's office. I left my position with the district attorney's office to defend. So then I went into private practice for a while. And in our county at that time, we could be both in the district attorney's office and in private practice. So I had private practice, and I was the first assistant district attorney when I went back in. District attorney retired. Was appointed, went up on the bench. I then became a district attorney for 2 years, maintained my private practice, ran for re-election twice, was elected twice. So I served about 10 years in the district attorney's office. In 1977, they opened up a 5th judicial position in Fayette County. I ran for the office, and I was elected. I went on the bench. I served on the bench as a sitting judge until 2000. I was retained twice. And our retentions are usually very easy. My first retention was, there were 3 questions on the ballot.
Disciplinary board of the Supreme Court of Pennsylvania proceeding.
Should we build a new stadium for the Steelers? Should we build a new stadium for the Pirates? And then some other question. And people would come in and say, where do I vote no against those stadiums? Where do I vote? And I'm up there with them on a yes-no vote. So I was very, very worried about that. But I fortunately was retained. And then 10 years later, I was retained. And that was the year, remember the year kick all the judges out?
Uh-huh.
In fact, one of the Superior Court judges lost the yes/no vote outside that divorce. So, and then when I retired as a sitting judge in 2012, I became a senior judge until I faced mandatory retirement again, 2020. And that's whenever I started doing the specialty courts. And in return, I got to keep my office in the courthouse.
So when you have, we did the purpose and kind of philosophy, how do you interact, even when you were the judge in the drug court, how do you interact with the participants?
First of all, I wanted to know as much as I could about them. And that was usually garnered.
This might have been the judge over the
that worked
lawyer when he was in drug
court program, veterans court program, than they were as a judge. You know, they held back a lot of judges. And so I relied on them, and by relying on them, I gained information about each individual, and then I was able to address them with that knowledge. Had I gone in blind, I might not have been able to. I always felt I wanted to have some rapport with them, where we looked at each other not as a judge, defendant, almost some two guys just talking on the street or something. And that's what I tried to attain. And that's why I kept notes on everything they told me. I asked about their families, asked about what they're doing with their lives. I'd address any issues they were having with them, and told me, "You're doing great on this. We need to buckle up on this if you want to remain in the program."
So how did you first come to know Brian Salisbury?
I think, well, to say no, he came before me as an attorney with a couple of issues, a couple of cases. Then when I heard about his being arrested, my first thing is, how can an attorney throw away something they worked all their life to attain? And then I end up taking his plea and sentencing my plea.
Okay, so I'm going to show you what's marked as Petitioner's Exhibit E. And see if you can identify these documents.
Yeah, see, these stem from his sentencing proceeding.
Okay, and what do you remember from your involvement in those criminal proceedings?
Well, there was a plea agreement reached in the case, so sentencing was basically taken out of my hands. Except, do I want to accept the agreement and sentence in accordance with the agreement, or do I want to say no? I'm not satisfied with the offer. I can't accept this. And then at that point, he would have been able to withdraw his plea if it had not already been entered. I mean, if it had been entered, and try the case.
If you look back to what's marked at the bottom corner where it says Salisbury, if you look back to Salisbury 59 there's 44. So if you go back to 59.
What page? I'm sorry?
59. It's Salisbury 59.
Not 51.
59 and
that's the plea colloquy.
What did he plead to? And this is going to test your memory of the. Do you remember?
Well, they were both violations of the Drug Act. I think possession. I can't recall the
Okay, that's okay. I get it. And what is the plea colloquy? Is that something that occurred before you?
Yes.
And then would you ultimately?
Well, they would have filled this out and given it to me at the time.
And
and by day, I'm speaking of Mr. Salisbury's counsel.
And then you would accept that plea? If you look at Salisbury 69?
I accepted the plea, and I believe I sentenced him in accordance with the plea agreement.
So is Salisbury 69 the order where you accepted the plea?
67 is the sentence. Yes.
And that's obviously your signature on the bottom there, correct? And then if you go back to 67, you said, what's that?
This is the actual sentence that I imposed.
Do you remember what the sentence you imposed was?
Now that I'm looking at it, I did. I gave 11 and a half to 23 months with a consecutive 2 years probation.
And is that what you were required to do?
If I accepted plea agreement, I was required to do it. And I accepted the plea agreement. I felt that it was a fair offer. It was within the guidelines.
Do you have any recollection at this point of what happened, where Brian went from there, from your sentence?
No.
And what happened? You don't remember that?
No, I would not have known. I don't know where they would have sent him to serve his sentence. I think they might have just kept him as Fayette County Prison. Sure.
Okay. Do you remember, did he violate? He
did.
And do you remember what you did at that point?
Not offhand, I violated him. He probably resentenced him. I think I sent him to prison then. I believe, not I think, I know I sent him to prison.
Okay.
I felt he had his chance and he messed it up.
And you know from later that he had another conviction and he violated a couple of more times, but were you involved in that?
I don't believe so. I can't recall.
When's the next time you personally recall being involved with Brian?
When he came into our drug court program.
And do you remember what that was following? What conviction that was following after?
No, I believe it was a possession. Or he'd had some incident that he found him unconscious. I don't know if that's the time he died or not. I know he died once, maybe twice, and brought back with Narcan.
And that was from overdosing? So tell the hearing committee, what was your impression of Brian's participation in the drug court program?
He was a shining example. He dedicated himself to the program. He dedicated himself to others in the program. I mean, I always felt that someone that had an issue would listen to someone who had the same issue more than they would for some old guy in a black robe sitting up on the bench. So whenever he gave the time that he gave to those in the program and the things he did to help others with his affliction, that impressed me tremendously. It showed me that there was still some hope.
Based on your interactions with Brian, do you believe he's now morally qualified and fit to resume the practice of law?
I do. I know he seems like he has a good work ethic now. I see him a lot. He's worked for the firm of Davis and Davis. And so I see him a lot around the courthouse. I think he's come a long way. If I didn't think so, I wouldn't be here today to testify.
Has he shown trustworthiness, reliability, honesty with you?
Well, I think that the fact that the firm has been working for them, and it's been, I don't know, I'm going to say 2, 3, 4 years that he's been working for them. The fact that he's still there shows me that he does.
Do you have anything else you want to tell the hearing committee about Brian's character?
I know he's all, when he brings things to the courthouse for them, he's always polite, manly. I believe what he's gone through has been hard on him, but I believe it's changed him. He's become a better person. He's become a stronger person. He's become someone I think you can depend on. He would be working for the Davis brothers, I can tell you that.
What about his reputation in the legal community now?
As far as I know, I really don't discuss much reputations, but he seems like he's fit in, like his past never happened.
That's all I have.
I have no questions. Thank you.
You're welcome.
You can actually leave that there.
So this is the drug court judge that sentenced the attorney to jail when he had drug problems, now coming in testifying on his behalf to get the attorney reinstated to the bar.
Oh, okay.
It was 1996, and he doesn't remember me.
I remember. Next.
Petitioner calls Sam Davis, and he's here, so okay. I'll go out and.
Perfect.
Let me jump away from this just for a minute here. We might follow another court. This is a slow proceeding. It might go over 2 days as they hear all this evidence to see if they can bring him back. If your comment has been deleted, or if it shows that if you type something and it's just not showing up, guess what? You have found one of our banned words. Congratulations. It probably means whatever you're talking about might not be good for the channel today. I'm not going to say what that might be, but try changing the topic completely. Try using different words, not to get around the banned word, because that would be a violation of our rules and it might find you being banned yourself. But try talking about what's relevant in court instead, and you'll probably find that chat works just fine. Anyway, good morning, and welcome all. All right, let's see. We have a little bit going on with Judge Simpson. I wanted to pop in and see how he's doing today. Let's see. Judge Simpson, are you there?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
你了解，如果你认罪的话，您并不会有任何形式的，就是审讯。
好的。
Okay.
You might not want me to call, Phil. I've had bad luck with the IRS.
Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak on your behalf or to have this court order their appearance.
所以您在这种情况下的话，也会放弃一些权利。这些权利包括就是您要求证人来替您说话的这个权利，或者是就是法院命令证人来作证的这方面的权利。
Mandarin Chinese Very difficult language.
You also understand you're giving up your right to see, hear, and question all witnesses against you.
你也了解您是放弃那个权利，可以要求任何的证人，就是见任何的证人或听证人，或者是询问证人的这个权利。
You're also giving up your right to be a witness for yourself or to remain silent and not have that silence used against you.
您也会放弃那权利，就是你为你自己作证，并且就是还有放弃关于保持沉默，不能到时候不能够使用您说的话来，就是说来对付你这方面的权利。
You're also giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
所以您也是放弃那权利，就是说是有就是在合理在就是说超越合理怀疑的情况下，就是就等于说你就是必须要好像事先证明你的清白才能够判说是有罪，你也放弃了这个权利。
Yes.
He responds in English. I love
yes.
that.
You understand that you're giving up your right to appeal of right.
你也了解您是放弃你申诉的这个权利。
Yes. Yes.
Yes.
Are you on probation or parole?
您现在有在缓刑吗？或者是就是说有人家在监视您吗？
监视是没有。
No. Prosecution, no, probation, no.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
为了要让你能够认罪的关系，有没有任何人给你答应，就是我们刚刚没有列出来的这些项目呢？
没有。
No.
Has anybody threatened you or coerced you in any way to get you to plead guilty?
有没有任何人威胁你或者逼着你认罪呢？
没有。
No.
You're doing this voluntarily and of your own free will?
您是自愿并就是你是情愿而且自愿的做这个决定吗？
是的。
Yes.
And also because you believe that you're guilty of this offense?
并且你也是认同说您这个就是说犯罪的话，您是认同说你是有犯罪的是吗？
是的。
Yes.
Paula Mack, welcome to
On
the gallery.
July 28th, 2024, Gulfside Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
It's a long one.
所以在2024年7月28号，是在高塞路，这是在 Pittsfield 镇，Washtenaw 县政府 Michigan 州的时候，当时您是有操作一台车吗？
是的。
Yes.
Prior to operating that motor vehicle, had you consumed intoxicating liquor or alcohol?
在操作那台车之前的话，你有没有喝酒或者使用任何的酒精呢？
有。
Yes.
Yes.
Do you recall what you had and how much?
您还记得那时候喝了什么，并且喝了多少呢？
Bet 2 beers.
我好像啤酒，我喝了啤酒。
I drank beer.
Were you stopped by the police or was there an accident?
那时候是警察把你拦下来，还是当时有发生意外呢？
没有发生意外，是警察拦我下来的。
There was no accident. The police stopped me.
Why did they stop you?
他们为什么把你拦下来的呢？
他们说好像我 我有点偏线嘛。
So they said that I kind of went over the line a little bit.
Little bit.
Are you disputing the right of the police
to stop you?
To stop you in this case?
您在这个案件中的话，您是否就是说有对于警察拦住你有这个权利是否有抗议呢？
没有。
No.
Were you ultimately arrested?
后来你有被逮捕吗？
有。
Yes.
Were you taken to the hospital or police station for a blood draw?
Or the blood draw.
结果后来是带您去医院还是去警察局抽血呢？
去医院。
Hospital.
Do you know what the results of that blood test were?
您知道那抽血报告结果是什么呢？
他说我酒精有超标。
They said that alcohol level exceeded the requirement.
Your Honor, the alcohol level was 0.233.
0.233, that's more than 2 beers.
法官呢，酒精的那程度，那量出来是0.233。
Do you stipulate to that test result, counsel?
Yes, Your Honor.
所以辩护律师，所以您是就是说你是就是说在这个案子的话是有就是说补上这个事情吗？法官是的。
Sir, do you have any reason to dispute that blood test result?
先生，你有没有任何的原因想要就是抗议关于呢血液报告呢血液结果？
没有。
No.
I like Justin Ford's glasses.
Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
My client plea.
Go ahead, Madam Interpreter.
所以辩护律师，所以我是否已经达到法院这边的规定之后来那个关于，而且就是说有没有配合所以就是说辩护者的话，他的就是说答复的话是有配合吗
？Lots of words.
Yes, Your Honor. My client plead guilty.
法官是，sorry。法官是的，所以我的就是说我的辩护者的话，他是认罪。
And Pittsfield Township is satisfied.
之后 Pittsfield 镇的话也满意了。
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
所以法院的话是接受辩护者的这个。答复之后第一项的犯错的话是不受理了。
Defendant is referred to Von Swartz for an alcohol screening and assessment, and to the victim's impact panel.
所以到时候这个所以辩护者的话，到时候会给他转介到 Ron Swartz 那边的就是一个酒精方面的一个就是说评估并且就是说也会转介绍到就是一个受害者的那组织那里去。
Sentencing will be December 11th, 2024 at 9 a.m. or as your invite indicates.
Helena Handbasket, thank you very
判
much.
刑的话会是在于2024年的12月11号早晨9点钟，或者是根据你的邀请上面指定的日期时间。
I am signing an order that defendant is to report to community corrections within 24 hours for placement on a SoberLink testing device.
所以之后我是会签一个命令，要求辩护者到时候会需要去社区的，就是说唤醒他们的部门那边，在24小时之内，之后到时候他们会提供给他一个就是有没有经济方面的一个测试。
Bond in this matter will continue.
所以关于这个事情的话呢，这到时候会在往后会继续。
Madam Interpreter, I'm going to put you and the defendant into a breakout room with my probation department. If you could help us out with that, I would appreciate it.
Yes, Your Honor. 好，那所以现在的话，法官会把我们放在一个分开的另外一个房间去，我们会跟缓刑官就是继续讨论。
好的。
Yes.
All right. Thank you, Madam Interpreter. Wonderful job as usual.
Thank you very much, Your Honor, for using our services.
Thank you.
Have a great day. Bye.
谢谢你。
Thank you. 谢谢。
All right, we'll put you into the breakout room.
好，请等
Thank you,
等。
Your Honor.
Thank you.
Go Raven.
Did he just say go Ravens?
They're not here anymore.
Did he just say go Ravens?
But then at some point he signed out along with his client. They were signed separately, and I have not heard from his office.
And this is a Russian interpreter.
Correct. So
You have not ordered one.
Correct.
Court does call the cases of the people versus Mikhail Hasanov.
I exchanged emails with Mr. Bruce this morning about these cases, and I understand he was on and signed back off. So I'm not entirely sure what's happening.
I don't either. I had his client, and he wasn't here. They said he was having a problem. So we waited. And then they were here, and then they signed off. Are you going to have any objection to me just adjourning this out to the 20th?
Your Honor, I would ask if we could actually go to December the 4th. I'm not going to the ADA covering on the 20th.
That's fine. All right. You're not going to be here on the 20th?
No, Your Honor.
Who are they sending?
I don't know.
Okay.
Do you have a preference?
I object.
I know. Do you have a preference?
Judge objects.
Well, I'll call. All right, thank you.
Thank you, Your Honor.
All right, I will adjourn these matters out to December 4th,
Thank you, Your Honor.
2024 at 9.
That's fine.
Are we ready set up yet or no?
I will be in just a second.
All right. Court's going to take a brief recess. Let us set up for the next block, and then I'll come back out and we'll start calling cases, folks. Okay? Court's in recess.
As the court goes into recess, we're going to jump back down to Chisholm's courtroom really quickly, see what's...
We would waive formal reading, stay on mute, ask the court to enter a not guilty plea on his behalf, and he is also requesting appointed counsel going forward, please.
Thank you very much. Mr. Hawkins, you understand what's happening this morning?
It's a little loud.
Very well. The court's entering a not guilty, repeat, not guilty plea on your behalf.
I repeat, not
Court-appointed
guilty.
counsel will be noted and approved. You are to provide this court with a new address, so an address different than 4310 Albert, within 24 hours. So before lunch tomorrow, the court needs to know where it can send you court notices that will advise you of your next court dates, and the court also needs to know where you are. So please keep an eye out. You need to respond actively to your duty to this court. That being said, you'll also hear from new defense counsel. They're going to want to team up with you, so together you can select how you wish to manage this case. In the meantime, Mr. Hawkins, the court does have to consider the issue of bond, sometimes referred to as bail, on the television. That's not designed to prejudge or punish you. The law presumes you to be innocent of this charge, but the court must set bond in order to ensure that you do reappear and afford any necessary protection to the public, which specifically would include Candace Hawkins. Ms. Costello, what do you wish to share in that regard?
Your Honor, as to bonds, my client did indicate to me that he is on probation or parole, that he had just recently successfully graduated from the drug court program in Warren. That was for a drunk driving second offense. He is gainfully employed. He's 40 years old. He's a chef. He works at 2 different restaurants. My understanding is that he has been married since April to the alleged victim here. He maintains innocence in this matter. We would ask that the court consider releasing him on a personal bond. He intends to, of course, appear for court. He's going to secure housing while this case is pending. I would just ask that the court consider allowing a one-time police escort so that he can retrieve his belongings.
Thank you very much. Mr. Hawkins, the court has concerns about your circumstances. The court does not want you to answer any of these remarks. The court is simply perfecting its record. But you've had a few episodes and challenges over the course of years, and for whatever reason, a different way of managing your life doesn't seem to be leaching in at the moment. Most recently, it appears as though you were in fact, or are still, or just did finish a probation for the 42-2 district court. There are other matters that cause the court some concern. These following conditions will apply to your release. You will appear as directed for all your future dates. You will abide any valid order or judgment entered in this case. You are not to leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. Please do notify the court in writing of any change of address, telephone, or email. You'll be making reports to pretrial services, and you must contact them within 24 hours. So before lunchtime tomorrow, you will participate in a substance abuse testing or monitoring program. You are not to purchase or possess a firearm or other deadly weapon. You are not to assault, harass, intimidate, beat, wound, or threaten Candace Hawkins, nor shall you have any contact, direct, indirect, or through a third party with Candace Hawkins. You will not enter bars, clubs, liquor stores, 4310 Albert number 5, or any business premises in Royal Oak or Berkeley, except for work, court, or medical reasons. You may go to 4310 Albert one time when there is police department personnel available for a peace officer standby to retrieve as many items as you would need for instance, business travel. So we're talking about not moving pianos, just talking about an overnight bag and some clothes, okay? The court has concerns about alcohol and controlled substances, so there'll be 2 ETGs a week to test for alcohol, 3 controlled substance tests a month. At this time, the bond will be $10,000. Personal. What that means, Mr. Hawkins, is that you are making a promise that you will obey all those conditions and you will make all your court dates. If for whatever reason you miss court dates, you decide to violate the conditions, you decide to start ignoring the reasonable advice of your counsel, you could end up owing the court 10 grand and a bench warrant could issue for your arrest. Things will just get a lot more complicated.
All right. Well, speaking of complicated, we're going to jump to another Zoom
for the court
here in just a second.
or Ms. Costello at this time?
What 2 people, who do I need to contact within 24 hours? And how do I go about the test?
Pretrial services and
This is already well over a year
We're
old.
jumping to Judge Webster, who is live right
that?
now
November
with
2nd.
Yeah, because I
Mr.
never received the summons for
Riker.
the first court appearance. Never received it. I didn't even know about it until after they arrested me for failure to appear, or I would have appeared. And I fixed the problem. I went and got tagged the very next day. It just wasn't my vehicle, and I wasn't used to getting tags in that month.
You didn't get a citation with it?
I must appear ticket, that was it. And to contact the court by December 11th, which I did.
You just said must appear. You didn't need a summons. You had a must appear.
No, it said to contact the court by December 7th to find out my court date, which I did. And they said they would send me a summons in the mail, and I never received it. The very first court date I missed because I wasn't aware of it.
Your Honor, if I may.
Please.
Let's check the receipts.
One moment, Your Honor.
If I may, one moment. Computer.
Your Honor, what I can tell the court is I am showing that a summons was filed with the court on February 13th of 2024. There does appear to be an address on the summons that corresponds with the address on the ticket based off of a brief cursory review. I am showing a return on the summons with a handwritten notation, which would appear to indicate, quote, moved NFA, which I would interpret to mean no forwarding address.
Did you move?
Yes.
Okay, well.
But I was still checking my mail. Did they serve that personally or something?
They sent the summons to the address you'd given them for the ticket. If you had moved and didn't tell them, I kind of like being told to go take a UA and you don't do it. I have to presume that's a dirty UA. But you can't move.
I was still getting my mail there.
You can't move and tell us not tell us your new address and expect us to find you without a warrant.
But we did.
Well, I think what I'm hearing is it sounds like you're tagging on to what you saw happen with the gentleman before you who went to the hospital and treatment. You're telling me that you had...
I had enterocolitis.
You had what?
Enterocolitis.
And you were in the hospital and then you got COVID and...
My daughter had COVID, yeah.
Oh, your daughter had COVID.
We both went through COVID, yeah.
Well,
that's 2 weeks. I had 2 weeks alone out of work right there. I work with the elderly.
2 weeks out of a year. I don't know why, Miss Ferry, but I am just not finding a real credible reason why you.
The first appearance I had with you was in August.
What? What'd you say? I'm sorry.
The first appearance I had with you was in August.
She might have to check her attitude real quick.
But your ticket was issued long before that. You said you were going to look into diversion, and you didn't since August, did you? Did you turn in an application?
No, that's what I'm telling you. I didn't have the funds to pay for the application fee at that point.
I'll tell you what, I'm going to set this over, but you better be diverted or we're going to have to deal with this a little bit differently, because I can't just keep letting people say I'm going to be diverted and carry them over for a year. So, well, February 12th, you don't have this done by February 12th. We're going to set this for trial, and you're going to deal with this ticket one way or another. You've known you had this ticket pending since the officer issued it November 2nd of 2023, and you didn't make any efforts until we found you around August to take care of it. You just said, well...
I had contacted the court previously before that.
Excuse me?
I had contacted the court previously before that.
You said you contacted the clerk around March or somewhere around... When did you contact the clerk? Sometime shortly after the ticket, right?
Sharon is not impressed. Sharon
Before
Williams.
December 7th, and then I get
Of 2023.
Yeah.
And then you didn't contact them again. All right, you can go. Thank you.
Okay, Judge, the last one I have is Tommy Robertson with an R.
Tommy, come sit down in front of this little camera. Come look at the judge. Mr. Regier, I heard that Judge Webster got mad at him the other day. I haven't seen that clip yet, but...
We're on the record in 2023, TR 1915, State of Kansas versus Tommy Joe Robertson. Jared
Joe.
Regier for the state. Are you Tommy Joe Robertson?
Yes, ma'am, I am.
What did you allegedly
Defendant
do?
appears in person and pro se. Thank you. Okay, you had a hearing set October 25th, 2023, over a year ago.
Yes.
It says you failed to appear.
FTA.
Apparently something about a 1+ with video, but no audio.
Right.
The clerk's office called and told you to connect with audio, but you never came back. So you got a bench warrant, $1,000 cash or surety on October 25th, 2023, and apparently that warrant finally got served on you recently.
He did the, I'm on Zoom, but I can't hear you, Judge.
You made your bond.
Trick. And then he just
Or not.
bailed.
Yes.
$1,000 cash or surety.
Yes.
All right, sir. You have in count 1 operating a motor vehicle with an improper stop lamp or turn signal. That is an infraction. It carries a $45 fine.
Taillight
In
out.
count 2, you're looking at a Class B misdemeanor crime, operating a motor vehicle without proof of insurance. Both of these incidents allegedly occurring on May 24th, 2023.
That is correct.
She knows that she's reading the record. And then you just bailed on court until we picked you up on a warrant.
The B misdemeanor carries a fine of $300 minimum, up to $1,000 maximum, and up to 6 months in jail. Do you intend to hire an attorney, apply for court appointed, or represent yourself, sir?
Ma'am, after I got pulled over, I went and got my insurance, and I obviously haven't been back before you, but I have proof of insurance, and I got my stoplights fixed. I got a receipt for that. So it's proof of insurance, and I was plead guilty on the stoplight infraction.
Welcome, John. Thanks for joining us.
But you got the insurance after the fact.
No, I had it. I went down to get the actual paper because I didn't have any proof on me at the time.
Okay.
So after I got pulled over and the officer let me leave, I went straight there and got proof.
And then you didn't
By
come
chance
to court
take it
for
to
a
the
year.
county attorney at any point?
I wish I would have.
I do too. You know, the statute says you have, as I recall, it's about 10 days after the stop to take your proof to the officer that stopped you, and he will not file the ticket. And it doesn't say the county attorney has to dismiss him or should dismiss him if you bring in proof to court. But as a longstanding tradition, you know, the court's understanding, the county attorney's understanding, and even though you go well beyond the 10 days, in your case, a year and a half to bring it in,
she's going to cut him a
we
break.
try to be accommodating.
Sure.
But they don't have to. They don't have to dismiss that as long as you've waited.
Right.
Yeah, are you?
Mr. Aguirre, thoughts? It's a tiny ticket. It's a tail light and failure to have
Mr.
insurance.
Aguirre, have you anything to say, any recommendations on how to proceed? He's saying he thinks he wants you to dismiss the insurance because even though he hasn't provided proof in a year and a half, he thinks he has it now, and then he'll plead guilty to the stop lamp. What's your response?
Well, Your Honor, it would appear, notwithstanding the allegations presented by the defendant, it would appear he has stated on the record that any documentation has not been provided to my office. Certainly, the court is well aware of where my office currently is located, and such information can, of course, be provided to my office via email. But at this juncture, I do not believe I am in a position to dismiss count 2 as charged before the court.
He's playing hardball.
Mr. Robertson, I will set this over to February 12th,
Just give him an extension.
2025 at 9 a.m. And you better be here this time. Don't
Yes, ma'am.
disappear on me again for a year.
No, ma'am.
In the
I don't
meantime,
know
get
at
something
this
to Mr.
point,
Aguirre.
Like Mr. Aguirre says, he has no reason or evidence to dismiss that insurance. You can take it down there and see what he thinks about it.
Okay.
If he wants to go to the effort this late to try to find that it's verified, you know, anybody can bring in a sheet of paper, especially copy machines like they are now. So you get that down there, talk to him about whether you want to divert that stop lamp or plead guilty to it or whatever, but I'm setting this over, continuing this again, all time counting against you. And this better be resolved on or before February 12th, 2025 at 9 a.m.
What shirt
Condition
does,
your bond
does,
requires that you be back
Kaylee
here
have
ready
there?
to proceed at that date and time.
What shirt
Yes,
is Kaylee wearing?
You want an attorney, you have the right to an attorney. You hire that
American
attorney
Freedom?
well before that date.
I thought it was a band.
If you need to apply, you apply well before that date, at least a month before. Either have your attorney hired a month before or apply a month before. That's if you don't get diverted or if you don't want to waive your attorney. No
Yes,
more
ma'am.
continuances.
Sure.
Mr. Regier, anything further?
No, Your Honor.
All right, thank you. You may go, sir.
Have a good day.
You're welcome. Where are you going, though? Where are you going right now?
County attorney.
Court security prompts him.
You get down to the county attorney's office.
I'll do it right now.
Too good of a guy, deputy. You want to help them all. Okay. All right, who do you have? Anyone else?
That's it.
I just telling him where it's at.
What's that?
I said I was just telling him where it was at.
Okay. All right. But no other people?
No, that's it. I'm
Okay.
done.
Thank you.
Now let's do some of the people on Zoom here.
All
I think
right.
Sharon's been here a
Sharon
while.
Williams. Sharon
Sharon's up.
Williams. We are on the record in 2024 TR 832, State of Kansas versus Shannon Latrice Williams. Jared Regier appears for the state. Are you Shannon Latrice Williams?
Yes, ma'am.
Ms. Williams, the defendant, appears in person and pro se. And Ms. Williams, you're here on one count of driving while suspended. Your first appearance, we talked about that on June 5th, the 24. You were going to look into diversion and come back August 21st if you didn't get diversion. August 21st. You were going to hire an attorney.
Mm-hmm.
You had failed to report to booking and processing after the last hearing as I had ordered you.
I got that done the day after, that same day actually.
After I ordered it a second time. Yes, I see that. Good. But you didn't apply for diversion, or they denied it? Which happened?
No, I had went and talked to an attorney. I had access to Legal Shield through my job. So I was able to contact an attorney office and they had wrote up a letter for me and they sent it to me. And they also sent it to, I guess, the Kansas Department of Revenue asking like what the issue is, because I showed them the proof that my license wasn't suspended and it was just saying that it was suspended. So they told me to sign the paper and they sent it off to them. And they said if they needed anything else, that they would contact me and let me know, or if I hear anything from Kansas Department of Revenue to contact them. But I never heard anything back.
What's the date of your letter that they sent?
October 18th, 2024.
Too late.
Mr. Regier, have you heard anything from anyone since that last court date?
Your Honor, if I may take a minute of the court's time to review my notes.
Sure.
Let me download telepathically the notes into my current memory bank. So Sharon's saying she never had a suspended license. It was an error in the system. She used Legal Shield, which is a bulk attorney, bulk legal services system that's paid for in advance, sometimes through work. I got a strongly worded letter written to the Department of Transportation saying, "Hey, why did you screw up?" I love Mr. Regier. Oh my goodness. Bless you. Not a sponsor. Not a sponsor. Could be Legal Shield. Hit me up. Hit me up. I think we'd be a good fit. Mr. Regier has now read all the notes for all the cases for all the state using his direct download capability.
Your Honor, notwithstanding the allegations presented by the defendant, I am not showing any documents in my file to that effect, nor am I showing any documents filed with the court to that effect. It does appear that a certain filing was presented to the court on August 28th of 2024. Of course, I have no knowledge as to that either.
What was that date?
The file damp on that appears to be August 28th of 2024, Your Honor, based off my understanding.
I see that you did apply for, or at least, did you apply for an attorney on that date of August 28th?
Yeah, the day after my last court date, I drove down and applied for an attorney, but I never heard nothing back. That's why I went through my job, just to make sure I can get in contact with somebody to tell me what I should do.
Okay, I think that might be the document that counsel's in reference to.
The result might be several weeks.
Appointed attorney application.
Takes several weeks for a Supreme Court to make a ruling, usually, sometimes
Does
months.
appear to be appropriately signed by you. At that time, you were unemployed, though, it says.
What is Jacob Jabin
You had
playing
been
with?
for a month, but you were looking for a job. Previously had been at Clipboard Health, is that right?
Yes.
Okay. And since this application, you have been employed? You've gotten a job? And where are you working now?
I was doing a contract in Ellsworth, Kansas through Good Samaritan Society.
I think Jacob Jabin is using a grinder right now, or possibly a can of chew. I can't quite tell which one it is.
Well, you certainly were eligible then, and I do see I've signed that. Let me see. I signed the front page, but let me see what that says, if anything significant. How much are you making per month now?
If Jacob rolls one,
I want to say about $6,000 a month.
Yeah, see, that puts you way over. Unless,
so help me, if he's playing with paraphernalia while he's waiting for a court appearance, I don't know what that is.
well, it's a situation where when you turned in the application, you were eligible. Based on the information you supplied therein with reference to expenses, dependents, and such, with what you've said today, you would not be eligible. How do you want to proceed? Do you want me to set this for trial in February, and then in between now and then you can talk to your work attorney and see if they've accomplished anything? Because what I'm hearing you say is that you don't think you were suspended in December of 2023?
Yes, ma'am. I know for a fact I wasn't.
Okay, even though your record says you were, you shouldn't have been.
Yeah.
Well, why don't I do that? I'll continue a not guilty plea and set this for bench trial. And that was February 12th? Jen, what was our bench trial date, February or January?
If you're wanting bench trial, that is January 22nd.
Okay, January 22nd, 2025. You must be back here by Zoom for bench trial.
Okay.
I imagine if your attorney is successful in getting that suspension to disappear from your record, the state may not have evidence or desire to proceed. They may dismiss, but as long as that's showing up on your certified driving record, that remains evidence in the case. So make sure you get all that squared away and be back here for trial January 22nd at 1:30.
So Mr. Lopez is playing GTA.
You're welcome. Thank you very much. And
or Fortnite. Can't quite tell
excused
which.
at this time. Continued on your 2000 OR unless Mr. Regier, there's something else.
Not at this time, Your Honor.
All right. Thank you, Ms. Williams. You may go.
So Sharon used the Sharpie, marks it on the calendar.
Patricia Barnes, or did we already do that?
Kelly's just finishing up some of her nails to get them painted properly. Jacob has been sitting patiently on the side of the road.
Patricia Barnes here, Barnes.
With what may be a dispensary container.
On the record in 2024, TR 1675, State of Kansas versus Patricia Ann Barnes, or Barnes, VARNES, Jared Regier for the state. I believe the defendant had asked that we set this speeding charge of 89 and the 75 on the docket today. Did she by chance pay, Jen?
One moment, Your Honor. I'm having a hard time finding her on the docket.
Okay. Are you looking at, it's not Barnes with the B, it's Barnes with the V, Victor.
Thank you. That helps.
Yeah, it sounds like Barnes because we're not used to seeing Barnes.
I am not showing that she paid today, no.
And are you showing that she has $240 and what is that? That's not suspension fees, surely. Like she only has the one ticket, so wouldn't it be like one something?
I'm showing 132 in fines and 108 in court costs for a total of 240.
Okay. Yeah. Well, let's do a clerk's letter of suspension notice since she's not here. And she asked that be put on here, and she hadn't taken care of the ticket since June of 24.
So now her speeding ticket becomes a driver's license suspension because of failure to appear for court.
I'm looking for ADEM, maybe Adam, last name BOULDJADJ. On the record in 2024, TR 1491, State of Kansas.
There he is.
By Jared Regier. Defendant appears in person.
I don't know why Borat jumped to my mind. That's not the correct
that is
pronunciation.
State of Kansas versus, how do you pronounce your name, sir?
It's not Borat.
Adam, ma'am.
Adam, and your last name?
Bulljage.
Bulljage?
Yes.
Okay, State of Kansas versus Adam Bulljage. The defendant does appear in person and pro se.
Yes, Your Honor.
Mr. Bulljage, you are charged in count 1 with operating without a license. We went through that and the other charges August 14th.
Yes, Your Honor.
You had verbally waived your right to counsel and you wanted to look into diversion.
Yes.
For count 1 as well as those remaining counts of insurance and failure to yield. But I don't see a diversion application has been filed. Have you filed one?
I did, Your Honor, and I got refused because they said because the ticket involved an accident in it, and that's why they.
Okay, so are you wanting an attorney or are you wanting to represent yourself?
I'll be representing myself, Your Honor.
You understand you can hire an attorney, and if you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed.
I do.
And even though you know that, you still want to proceed on your own behalf?
I do, Your Honor.
All right, and that's what you told me last time, so I will have the record reflect, both in the journal entry of Mr. Regier and the docket notes, that he is maintaining his prior waiver of counsel.
Thank you, Your Honor.
You're welcome. Now,
if I might take a moment of the court and
yes, go ahead.
I was wondering. When I got into that little accident. They took my. I'm not from here. I'm an international student. I was at Butler Community College before I got transferred, and I had an Algerian driver license, but according to the law, after 1 year, I can't drive with it. It becomes invalid, even though it's not expired. So they charged me for driving without a driver license, and I was wondering what should I do next after I got refused in diversion.
Well, my thought was if you think you might have any defenses, talk to an attorney. Do you just think you wouldn't qualify for a court-appointed attorney? Think you have too much income, or you just because to me it seems like if you have questions, those would be good questions for an attorney that could represent your interests.
I was just wondering what's going to happen like after.
Well, I'll tell you what I could do is let you, since you're representing yourself, take a brief breakout room with the prosecutor and see if there is anything the two of you can conclude. Mr. Regier, would you be willing to do that?
One moment, Your Honor.
Okay.
One moment. Processing. Calculation complete.
Your Honor, I am not really sure at this juncture if that is something the defendant is willing to do. Well, certainly I cannot speak for him, as I do not represent him in these proceedings in my role as prosecutor. I suppose if the court is going to find that the defendant's prior waiver of counsel is continuing.
Phil,
I am fine with that.
You can sponsor the channel.
And it looks like the insurance was dismissed for proof back on June 27 of 24. So he's looking at no valid driver's license, count 1, and failure to yield on count 3.
I think
Mr. Bull Judge, are
we have
you
to talk, Phil.
wanting to talk to the prosecutor to see what he would recommend and if it's something that you would agree to or not?
Yes, Your Honor, I would love to.
So, Mr. Regier, there's where we are. Do you want to talk to him?
Your Honor, if the court is prepared to grant me a breakout room for that purpose, I believe I am in a position to do so.
I am prepared. And Jen, if you would put them in a breakout room, please.
A simple yes
or
would
whoever's
suffice.
running the breakout room.
Mr. Regier.
Thank you. I think that's you, isn't it, Jen?
Now we got a brief break.
Yes, it is.
Because
we can't double duty.
We can't really move on with Mr. Regier gone. So everyone just take a deep breath. He is the prosecutor. Sort of needs to be here for all the other things that are about to happen. Phil, here's what I'm thinking. I'm thinking next time I get a spam call and they say, hey, you're about to lose your travel credits, I can tell them that, no, actually, I have Travel Credit Shield, which protects my travel credits from being deleted, from being disposed of. I think I could do that. But I think at that point they would hang up on me, knowing that I called their bluff. Let's see. Mr. Regier is one of a kind, although his understudy is amazing as well. Occasionally you'll see his understudy here in this court. Both of them are absolutely amazing. Travel Credit Shield. I just have to remember. You guys remind me when I get next time Mr. Bourne, Dwayne Bourne gets a call about travel credits. Remind me Travel Credit Shield, and I'll take it from there. I could tell them I printed my own travel credits. Callie is admiring her painted nails. I'm not sure why she turned her camera off. She should be done by now. With multipliers, yes. Tammy Marshall. Oh, my comment was selected. I feel official now. Tammy, you should feel official. Welcome. Good to have you here. There is an argument that...
All right, we
Jacob's back.
are back on the record in 24 TR 1491, State versus Adam Buldajaj. Please announce, same parties as before. Mr. Regier, any announcements?
Not at this time, Your Honor. As the court is well aware, in my role as prosecutor, I do not represent the defendant in these proceedings, and I therefore cannot give legal advice.
Okay. Mr.
Wow, he's been a
Buldajaj,
stick in the mud.
understand his comment that he can't give legal advice unless perhaps you were back there asking him for legal advice. My intention of putting you in the breakout room was for you to find out what he would recommend if you were to enter a plea and see if it was something you could agree to. It was not for you to ask him to advise you on what to do. So maybe we had a misunderstanding.
Do you want to go back again?
I'm really sorry, Your Honor. I'm not familiar with the American court system, and I couldn't reflect on what you're saying. But what I did, I asked him the same question that I asked you before we went to the break room. And I do really apologize to you and to him as well.
Well, there's no reason to apologize. You haven't done anything wrong. Mr. Regier's right. We can't advise you, but we certainly can give you information within our jobs to
go get a lawyer.
Maybe let you make your own decisions. I still think you'd be better off with an attorney representing you that could answer the questions you're seeking and maybe negotiate an outcome on your behalf. But since if you continue to be insistent that you don't want an attorney, I can tell you, as I have before, that on count 1, driving without a license, the statutory penalties could be up to $1,000 and 6 months in jail. But as a practical matter, if you watch the court very long, you're going to see that usually they end up with something far, far less in fines, and any sentence would result in probation. People hardly ever, if ever, go to jail as long as they're successful on probation for that charge. But that doesn't mean that's what would happen in your case. I can't tell you what would happen in your case prior to sentence or prior to even knowing if you're to be found guilty. The failure to yield right away at a stop sign, that I can tell you is a scheduled fine of $75, no jail time, and court costs of $108. So I don't know if that helps you at all in...
That did help a lot, Your Honor.
Okay.
For providing the information.
Okay, so do you know how you want to proceed at this time?
Yes, ma'am.
All right. How do you want to proceed on count 1, driving without a license?
Plead guilty.
I plead no contest, Your Honor.
Okay. And how do you plead to failure to yield at a stop sign?
Same, Your Honor. I plead no contest.
Now, you've made it clear multiple times you don't want an attorney. I heard there was an accident involved and you did have insurance. Do you have an attorney representing you in any of that civilly?
No.
Are you going to have, if you know?
In what? Come again, Your Honor? In what?
Is there any reason you'd be hiring one to your knowledge?
I don't think I will, but
Okay. All right, well, let's work then on these no contest pleas.
Get rolled.
By no contest, do you mean you don't want to admit these charges, but you don't want to deny them and take them to trial either?
Yes, Your Honor.
And is anyone making you enter these no contest pleas today by threats or promises?
No, Your Honor.
Do you understand that even though there's no contest, you'll still probably be found guilty and you won't be able to have a trial if you change your mind?
I do, Your Honor.
You won't be able to challenge a higher court to set aside the conviction. In other words, you wouldn't be able to appeal the conviction?
I do, Your Honor.
All right. Then I think you know what you're doing. You are doing this of your own free will and voluntarily. And so, Mr. Regier, have you a factual basis that if this were to go to trial, or so I can accept these no contest pleas?
Yes, Your Honor. Before getting to that, the state would be requesting the court to issue a ruling as to whether the apparent prior waiver of counsel is continuing at this time.
It is continuing.
Thank you, Your Honor. One moment, please.
Before you answer that, let me go back to Mr. Bull, the judge. I think I said that, I want to make sure on the record, that is count 3, not count 2. Count 2 was dismissed as no proof of insurance. It is count 3, failure to yield the right of way that you're pleading no contest. Count 3, right?
Your Honor.
Okay. Just wanted to clarify on the record that it's counts 1 and 3 that he's pleading no contest to, not count 2.
Thank you, Your Honor. Thank you, Your Honor. Insofar as the 2 counts currently before pursuant to the amended information, count 1 alleges that the defendant did then and there unlawfully operate a motor vehicle on a highway of the state without having a valid driver's license. The ticket in this case appears to refer to a stop occurring on June 1st of 2024 involving a 2009 GMC at milepost 4 on US 400 at milepost 302.5. The state's understanding is that is in Butler County, specifically between Augusta and Leon city limits. And if this case were to proceed to trial, the state's evidence would show that besides him not having a valid driver's license, as there does not appear to be any such indicated in the upper half of the ticket, pursuant to KSA 8 1430, quote, license or license to operate a motor vehicle means any driver's license or any other license or permit to operate a motor vehicle issued or under or granted by the laws of this state. Insofar as count 3 is concerned, the amended information alleges that on or about the same day, the defendant did unlawfully drive a motor vehicle upon a highway of this state and failed to yield the right-of-way from a stop sign to a vehicle in the intersection or approaching on another roadway so closely as to constitute an immediate hazard. Were this case to proceed to trial, the state's evidence would show evidence of the same, and that would be the officer's testimony to the state's understanding.
Very well. The court will not only accept the defendant's pleas as freely and voluntarily, knowingly given, but also the state's offer of factual basis to support, and will find the defendant guilty of count 1, driving without a license, and guilty of count 3, failure to yield right-of-way at a stop sign. Finding the defendant guilty, does the state have any recommendations as to sentencing?
One moment, Your Honor.
Your Honor, if I may speak.
I'll give you a chance to. Well, maybe I ought to let you talk first. What is it you're wanting to say?
I did got an American driving license in Florida after the incident.
Okay.
And I took some classes as well online.
All right. Thank you, sir.
And if you would want me to send the court the driving license or anything, just let me know.
I trust that
What's one
what
in
you're
Florida?
telling me is correct. I don't need to see the verification.
Thank you, Your Honor.
You're welcome. I'll consider that at your sentencing, Mr. Regier.
Your Honor, at this juncture, the state would be requesting that this case be bifurcated and the sentencing hearing be set over at an appropriate date and time. The state's purpose of the request is, as the court has already been informed, count 3 of the amended information does appear to allege failure to yield right away as stop sign, quote, to a vehicle in the intersection or approaching another roadway so closely as to constitute an immediate hazard. And the state does have certain concerns proceeding with sentencing without proper notification to the appropriate interested parties to give them the opportunity to speak pursuant to the Kansas Victim Bill of Rights.
So you're talking about the people that were involved in the accident or crash?
Yes, Your Honor, and that would be the state's request at this moment.
So it's your position that they are victims in this case?
It is, Your Honor.
Judge is not liking this. I think I'm sensing tension between Jay Revere and the judge.
I would also note for the record that on page 2 of the amended information, there do appear to be a number of listed endorsed witnesses.
So are you thinking you might be trying to seek restitution out of this traffic charge, the $45 traffic charge?
Your Honor, in response to the court's inquiry, I do not have any paperwork in my file to suggest that restitution at least applies at this juncture. Nevertheless, under the Kansas Victims Bill of Rights, it would be the state's position that those involved in the incident would have the right to speak at sentencing.
Do you have any legal authority that these people would be considered victims under the Kansas Bill of Victims' Rights, since the charge is a traffic infraction? Do you have legal authority that there are victims in traffic infractions?
One moment, Your Honor.
He's mad that he made her. He's mad that she made him go in a breakout room with Adam, and Adam asked for advice. He's like, I don't do that.
Your Honor, I would need to research that particular issue further, but I would note that the defendant, pursuant to the amended information, is charged for count 3 under KSA 8-1528 subsection B, which does specifically provide, among other things, quote, after having stopped, the driver shall yield the right of way to any vehicle in the intersection or approaching on another roadway so closely as to constitute an immediate hazard during the time when such driver is moving across or within the intersection or junction of roadways. It is also the state's understanding that a case involving a similar charge had recently come before this court, where the court did afford the individual involved in the incident to the right to speak.
I do recall that there was a traffic matter that someone did speak, but I don't believe that I necessarily treated him as a victim, but entitled him to speak. But in any event, I'm going to deny the request for bifurcation.
Ooh.
I am going to proceed with sentencing at this time. And Mr. Regier, I don't think I've heard any recommendations. If you do have them, I'll take them now.
Your Honor, if the court is denying the state's request for bifurcation for sentencing purposes in light of the particular facts of this case, the state is prepared to recommend for count 1 a $100 fine, $108 in court costs, a 6-month underlying sentence with 1 year of non-reporting probation, as well as the scheduled fine for count 3.
Wow.
All right. Is there anything else you would like to say further, Mr. Boldajaj, about sentencing before I pronounce it or determine it?
I'm sorry, Your Honor. I have nothing to say.
Very well. At this time, sir, your fine on count 1 is $100. Your fine on count 2 is $75. And your court costs are $108. I believe that comes to $283. Your sentence will be 120 days in jail, but you will not have to go to jail as long as you successfully complete a 6-month non-reporting probation. Non-reporting probation means you don't have to, as it says, report to anyone.
Just
But
don't get caught doing bad stuff.
For 6 months, you are ordered not to violate any laws, and you are to pay the total due of $283 within 30 days.
Yes, Your Honor.
So as long as you do not violate any more laws for 6 months, and you get the $283 paid within 30 days, you will not have to do any jail time. If, however, you violate any laws or you don't pay, then your 6-month probation can be revoked and you can be ordered to serve 120 days in the Butler County Jail. Do you have any questions about any of that, sir?
By probation, by violation probation, you mean any kind of
any?
I mean violating any kind of law, speeding, burglary,
drugs,
anything like that, anything, small, little, great, any violation of law. So don't violate the law.
Yes, Your Honor.
And you can pay that online at that Pay KS Courts. Did you write that down in the beginning?
Your Honor, I have it.
All right, that's where you pay that. You'll need to give us about a week to get the journal entry on file before you can pay that.
Yes, Your Honor.
But if you're closing in on the 30 days and you can't get the computer to work, you better call the clerk and let her know that you're having problems with the website. And you don't have to wait 30 days. You can just give us a week and you can call her if it doesn't work in a week or so.
Yes, Your Honor.
All right, thank you. Mr. Regier, anything further?
No, Your Honor.
All right, Mr. Buttigieg, anything further?
No, Your Honor.
You may go then, sir. Thank you.
Thank you.
You're welcome.
That was a long ticket.
John Richard Dietrich will be on the record in 2024 TR 2275, State of Kansas versus John Richard Dietrich.
John,
Jared
top left
Regier
corner.
for the state. Is John Richard Dietrich present?
Yes, ma'am.
Where are you, sir?
Right here.
Thank you. Mr. Dietrich, you, I believe, asked for this hearing because you've been charged with speeding 97 miles in a 70-mile-per-hour zone. This speeding charge is an infraction. It doesn't carry any jail time, but it does have a scheduled fine and court costs. You're wanting a trial, is that correct, sir?
This is not legal advice.
We will set that trial. That will be on a Wednesday at 1:30. And I understand is that February or January, Jen?
January 22nd.
He's
You'll
going to
need
do
to
the
be
old.
back here by Zoom, January 22nd.
Was the radar calibrated?
2025 at 1:30 for your trial, sir.
What date again?
Wednesday, January 22nd,
Thank you.
25.
I can't
1:30.
drive
All right.
55. Yeah, he couldn't drive 70. Did
If there's
97.
nothing further, you may go at this time,
Allegedly.
sir.
He's got
All
something.
right. Thank you. Have a great day.
Thank you. You too.
Bye, John.
Will now be on the record in 2024 TR 2043, State of Kansas versus Jimmy Franklin Gwynn Jr., Jared Regier for the state. Jimmy Gwynn Jr., are you here?
I'm not seeing Jimmy Jr.
Defendant
be
fails
at Jimmy
to
John's.
appear.
Bench warrant. 97 and a 70.
Looks like he was served August 12th, 2024 on driving while suspended second or subsequent and registration violations. Mr. Regier?
Yes, Your Honor. The return on the summons that I have in my file would appear to indicate residential address as of August 21st of this year. If the court is prepared to make a finding of legally sufficient service, the state is prepared to recommend a bench warrant in this matter. In this particular instance, in light of the charges currently before the court, previously referred to by the court, the state is recommending cash or surety $2,500 if the court is prepared to proceed in that fashion.
The court does find service legally sufficient and the defendant has failed to appear on same. Bench warrant will issue. Bond will be set at $2,500. Professional or cash required. Professional surety or cash required. Being in recess on Gwen, we'll now take up Henry on the record in 2024 TR 1521. State of Kansas versus Callie Renee Henry.
Callie.
Jared Regier for
Callie?
the state. You are Callie Henry, is that correct?
Yes, ma'am. It's Kaylee, but I go by both.
Thank you. Kaylee Henry, appearing in person and pro se. When you were here August 21st, 2024, you were going to look into diversion, but I do not see diversion has been filed. So, Ms. Henry, how do you wish to proceed?
So I was approved for diversion. It took them a little while to mail my the packet to me. And I went yesterday to pay and also to officially get on diversion. But with me working, I only had like a 2-hour gap. And I wasn't able to pay with my card. So now I have to just go get a money order, and which I was going to do either tomorrow before I go to work or Friday.
I will continue this at your request to February 12th at 9 a.m. so you can finish your process. Hopefully
Okay, and I know it was a 6-month diversion program. So in February, I will still be on diversion.
All right, well, I hope you're on there by then.
Okay, I will. I will be.
Yeah, if you're on diversion by then, you don't have to reappear.
Okay.
All right, thank you. You may go.
Thank you.
And Your Honor, that was February 6th for the next date.
February 12th.
Thank you, Your Honor.
Thank you.
You're welcome.
Thank you.
We'll now be on the record in Jabin 2023 TR 2936, State of Kansas versus Jacob Austin Jabin.
Is he
here for the state? Sir, is your name Jacob
guy that had the
Austin?
grinder.
Is it Jabin?
Yes, Your Honor.
And Mr. Jabin, the defendant, is here in person and pro se. When you were here, you were supposed to be here May 15th, but for some reason you weren't.
It was a failure to appear, Your Honor, yeah.
Okay.
It was an FDA.
Well, you're charged in count one with speeding 93 and a 75. That is a traffic infraction that does not carry jail time, but a scheduled fine. Then in count two, driving while your license was canceled, suspended, or revoked is a Class B misdemeanor crime.
He's in the car now.
The penalty could be up to 6 months in jail with probation often granted. And your fine would have to be at least $100, but could be up to $1,000. Also, if you're able to get your license back, you may be a good candidate for the state's diversion program. How would you like to proceed, Mr. Jabin? Do you want to look into diversion, or do you want to hire an attorney or apply for court appointed?
Your Honor, me and Mr. Regier had a conversation a while back about diversion, and he did send me that way, but I was actually denied for diversion due to my terrible driving record, which I'm owning 100%. I do have a valid driver's license.
Okay.
But explain why you're in the driver's seat now.
Currently, I've taken long strides to get that back, and I haven't had any infractions since.
Do you want to have an attorney look into this and attempt to negotiate that with counsel, or are you wanting to do that on your own behalf without counsel? What is your plan as far as an attorney?
Me and Mr. Regier did talk about negotiating it, and I believe we talked about him dismissing the speeding and then me pleading on the suspended. But I'm trying to avoid the 90-day suspension that Kansas will give me because I was convicted of it. So I would like to talk with an attorney to possibly amend the charge to driving without a license or something around those lines.
All right. Can you afford to hire an attorney, or do you need to apply for court appointed?
I really don't know. I'm commissions based, paid, and we haven't been working for the past month. So
where do you work? Who do you work for?
Safe Home Security.
How long have you been with them?
3 years.
So let's say you take your annual income that you report on your taxes and divide it by 12. What would that be per month?
Are we talking an average or
I was thinking average 1/12 would be an average. Although you say at the moment, what have you been making per month lately?
$2,000.
Okay.
$500 a week.
A week?
Yeah.
I don't think there's any way you're going to qualify for court appointed at $2,500 a week.
No, $2,000 a month.
Oh, okay. That's a different story.
I wish that was a month.
Yeah, that's a different story.
I wish that was wish that was per week. That'd be nice.
All right. Are you married or single?
I am single.
And do you have any minor children that you legally support?
I do not.
Okay. So what kind of rent or mortgage do you pay each month?
I pay $660 a month in rent.
Okay, let me get that first.
I think he's going to qualify here. Yeah, his pause 2,500.
And then utilities?
Electric's like 110. I don't have Wi-Fi. I don't have cable. Water's like 100. Gas is like 10.
$10 a month?
Yeah, it's nothing really.
Do you have any bank payments, credit cards, loan payments of any kind that you make?
Car payment?
No, I do make a car payment to the company every month.
All right. And how much is that?
Usually it's $1,200 a month.
That's $2,000.
And does that come out of the amount of money you told me about a while ago?
Correct.
Okay.
He's up to 2,000. He hasn't got food
your
yet.
Regular monthly gasoline and clothing and food and personal hygiene and things like that.
Correct.
1,200 plus
All right,
1,600
I will find that
plus
you do
100
qualify,
plus
and I will
150
appoint
plus
Attorney Darren Patterson, and I think you got his name at the beginning of the docket.
Yes, I wrote it down.
And he makes 2,000
That will be the attorney, and you'll need to call him as soon as this hearing is over, and give him your court date, which I believe, Jen, is at January 13.
Yes, it is.
All right. You and Mr. Patterson need to reappear by Zoom January 13, 2025, and his clients usually appear at 8 o'clock, so you'll need to be here by Zoom at 8 o'clock. And you are on bond. I believe you are.
I heard $2,000.
I am on bond.
500
I will
per
continue
month.
that bond with all existing conditions and the added condition that you contact Mr. Patterson as soon as this is over, and that you reappear on the date January 13th, 2025 at 8 a.m. 8 a.m.
Yes, ma'am.
Anything further, Mr. Regier?
No, Your Honor.
All right, thank you, Mr. Javin. You are excused at this time to call Mr. Patterson.
All right. Thank you guys. Have a good day.
You're welcome, and you too.
Drive safe and careful. Careful, Jacob. Can't get it to stop.
Okay. Jen, you can help him if you want. Thank you.
By help him
We
kick
are
him out.
on the record in 2024 TR 2042, State of Kansas versus Joshua Ryan Lego. Jared Regier for the state.
Mr. Lego.
And are you Joshua Ryan Lego or Lego? Anyone? No one answers by that name? Well, the defendant fails to appear on driving with the license plate not assigned. And it looks like he was served August 8th of 24. So recommendations, counsel?
Bench warrant.
Your Honor, at this juncture, the state is requesting a bench warrant, 500 cash or surety. Besides being served on August 8th, although the court may not necessarily consider this relevant, it would appear that service was personal service. So the state would respectfully advance bench warrant 500 cash or surety is appropriate, all things considered.
Court does find personal service very relevant. The defendant is issued a bench warrant for his failure to appear, and bond is set at $500 cash or professional surety required.
Thank you, Your Honor.
Thank you. We'll now be on the record in Lopez 2024 TR 2041,
Bottom left corner next to me.
State of Kansas versus Dominic Gerardo Lopez. Jared Regier for the state. Are you Dominic Lopez?
He is, and he's live,
Yes,
as it
I
says
am.
in the sign right above him.
And Mr.
Live.
Lopez is here in person and pro se on one count of operating a motor vehicle without a license. That is a Class B non-person misdemeanor. Maximum penalties could be up to $1,000 and 6 months in jail, but as you've heard earlier on this docket, that's usually
It's knocked down.
probation eligible and a much lower fine possible. You do have the right to an attorney. Are you going to hire an attorney, apply for court appointed, or represent yourself, Mr. Lopez?
I could do the court appointed attorney.
All right. Are you employed, sir?
Yes.
Where do you work?
I work at Tramec Plastics and Composites.
How do you spell Tramec?
TRAMEC.
Tramec Plastics and Composites?
Yes.
And where's that located?
Wellington.
Oh, Wellington. All right. And how much do you make per month, sir?
I'd say 1,500 a month.
Married or single?
Single.
Yeah, he qualifies.
Children?
No.
Okay. What do you pay for rent or mortgage, if anything, each month?
I don't pay anything.
Okay. Is that you live with a family member or friend?
Currently both. I live with my grandma and a friend when I have work.
Okay. Do you have work right now?
No, not today.
Oh, I see. Okay, so 1,500. Do you pay grandma any rent?
No.
Okay. Do you help in any way with her expenses?
I help with groceries sometimes.
Okay. Do you have any expenses that come out of this 1,500?
No.
You don't have a car payment,
He might not qualify.
credit cards, student loans, anything like that? How much money do you have saved up at this time?
Currently about 200 or 300.
Hang on, you have no expenses to make $1,500 a month. You have $200 or $300.
Sounds like all of your monthly income is disposable to spend as you will. Is that correct?
Yeah. Well, a lot of it does go to either paying people back for gas, getting gas, or car payments.
Well,
I thought you didn't have a car.
No, I do. It's under my mom's name though, so I have to send her the money in order for her to pay it.
Oh, okay.
How much is that?
So do you pay mom's car payment or just her gas or what? I don't understand.
I pay the car payments. I just give her the
Okay.
money so that she can pay it.
And how much is her car payment?
About $60, I'm pretty sure.
$60. And then what do you pay per month for gas to people? Do people help drive you around then or what?
No. Sometimes if I'm low on money, I'll ask for gas, but I haven't needed to for a while.
What do you spend all your money on? I mean, it's not a lot. He
With
doesn't earn a
what you
ton.
make per month
But where does he spend it?
and what little expenses you have, I will find your partially, at least indigent. I will appoint Mr. Patterson. Did you write down his name
Yes.
and his number? You need to call him as soon as this hearing is over. And we're going to set this for January
He makes $1,500 a month. He has
13th.
monthly bills of $60.
You need to be back here by Zoom, January 13th,
$1,500 is not a lot,
2025 at 8 a.m. by Zoom.
but he's always out of money
You
and
call
paying people
him
back.
today. Talk to him, see if he thinks diversion or something else might be available. That might be a good idea. If you don't have a driver's license and you can get one, he might recommend that.
I already have one.
All right. So talk to him about options and doesn't look like you're on bond, so I'm gonna need you to go into Sallyport breakout room with court security 2. And you're gonna get $1,000 OR bond. You won't have to put any money up unless you don't go out and get your picture and prints taken when they tell you to, or you don't come to court.
Okay.
So go into the breakout room, take care of that, and then call Mr. Patterson.
All right.
Okay, thank you, sir. And Mr. Regier, anything further?
No, Your Honor.
All right, then Mr. Lopez, you may go to the breakout room. Did I let him go? I think I said, okay, maybe he went.
He went to the breakout room.
Phew, thought maybe I gave him the impression he could just leave. Well, let's see. We will take up Shem Smith on the record in 2024 TR 1562, State of Kansas versus Dylan James Shin Smith.
Dylan.
Jared Regier for the state. Are you Dylan James Shin Smith?
The
If
muted
you'd
man
unmute,
with 4
please.
names.
Yes, ma'am. Sorry.
Thank you, sir. Defendant does appear in person and pro se. In count 1, sir, you're charged with ignition interlock violation, operating a car without required ignition interlock following a DUI. This is a Class A non-person misdemeanor.
What's the
If
clicking noise?
convicted, the maximum penalties could be a year in the county jail
Is it me?
and a $2,500 fine. That's the maximum.
Can you hear this?
In count 2, you're charged with driving while your license was suspended. The maximum sentence could be 6 months in the county jail. Your fine would have to be at least $100, but could be up to $1,000. In count 3, you're accused of, let's see, I think that's been dismissed. Let me double check.
And Your Honor, for the court's edification, my office did file an amended information in August of this year. It does appear to dismiss count 2, driving while suspended, while retaining counts 1, 3, and 4.
All right. Well, that is a little different than what I usually see with cases of yours. They dismissed count 2, the driving while suspended, but they did not dismiss count 3. That would be operating a motor vehicle without proof of insurance. And of course, if you had proof of insurance at the time you were driving on September 15th of 23, and you took that to the county attorney, they would probably dismiss that charge. If, however, you truly did not have insurance at that time, you would be looking at a B, non-person misdemeanor. The fine would have to be at least $300, but could be as high as $1,000, and the sentence could be up to 6 months in jail. Probation, though, is often available on all of these misdemeanors. In count 4, you are accused of violation of Kansas Wildlife and Parks law. The charge alleges that on or about September 15th, 2023 in Butler County, Kansas, you did commit an act or engage in an act within a state park or state lake, recreational ground, wildlife area or wildlife sanctuary, natural area or other area under the control of the secretary at Boulder Bluff area number 4, and that violation was contrary to the law and rules and regulations of the secretary. Mr. Regier saved me having to look up what KAR 115-8-13A is.
Yes, Your Honor. Pursuant to the same, quote, motorized vehicles shall be operated only on department roads and parking areas, except as otherwise established by this regulation or posted notice or as approved by the secretary.
All right. So it sounds like you were parking in an area you weren't supposed to at Boulder Bluff Park area. And that charge is a misdemeanor, a Class C, which means you could get a fine up to $500 and a 30-day jail sentence. Again, I'm giving you the extremes, not necessarily what we normally see. You do have the right to an attorney, and you can hire an attorney or apply for court appointed. You can waive your right to attorney and represent yourself. Do you want to have an attorney on this matter, sir?
Yes, Your Honor. I'll probably see about either retaining an attorney through the court or paying for one. Because at that time, I don't have that vehicle no more, but I do remember having insurance. Okay. And the interlock, I would just have to go back and backdate it to make sure.
All right. So tell me this. You said I wasn't clear. Are you planning to hire an attorney, or do you want to see if you qualify for court appointed?
We can see if I qualify, but I doubt it.
All right. Where do you work?
Ameritrack Rail.
Ameritrack Rail. And what do they pay you per month?
Qualify.
$4,000 roughly, 4 or 5.
Okay, that's a lot more than what we usually appoint for, but I do need to take into consideration your expenses. What kind of rent or mortgage do you pay, if any?
I have a $900 rent.
All right. And do you pay any mortgage, any utilities?
Yeah, the electric's normally like $150 a month, and then the water's normally like 60 or 80, and the gas is around 120, 130.
Yeah, I don't think he's going to qualify unless he's got like a massive truck payment.
What other expenses? Do you have a vehicle that you make any payments on?
No, my vehicle's paid for. I do have a son, but that's about it.
Okay, that's a good point. How many children do you have that you pay for?
1.
All right, and are you married or single?
I am single.
So you are a family of 2.
That'll help.
Any other expenses? Credit card payments, bank payments?
No, ma'am. Probation payments, but that's about it.
Probation payments, how much are they each month?
Here lately, I've been trying to do at least $100.
can't hear him now. The clicking's from his phone now.
Anything else that you pay for?
He's covering up his microphone. It's close. It's close, Judge. You make the call.
You are, well, you're still above the guidelines, so I can't appoint an attorney, but you can still hire one or take time to find one that can talk to you about this if you want, Mr. Smith.
Yes, Your Honor.
All right. So I will set this over to January 13th at 9 a.m. Now that's quite a ways off, so don't forget about it. January 13th, 9 a.m. Be back here by Zoom with your counsel, and those will be different Zoom codes. So make sure you have the Zoom codes. It looks like you're responsible and called in to look into that.
Yes, ma'am. Like I travel a lot for work, so it was hard for me to get on the connection. So I called and let the clerk know that I was having internet difficulties, and I got it figured out though.
Well, see, I'm pleased that people do that. You'd be amazed at how many just say, "Oh well, I can't come to court," and then I see them a year later. So thank you for being responsible. Do you have you given the clerk your contact information?
I do believe so. Yeah, I left her my phone number and my name.
All right. Well, just make sure you always check a day or two before that you have it, in case we can't get a hold of you. Well, it doesn't look like I'm showing that you posted. It looks like you were set a cash surety bond of $3,000. Did you post there?
Yes, ma'am.
And Your Honor, for what it's worth, I am showing such a professional surety bond with AAA Butler County in my file.
All right, it hasn't caught up to me yet, but okay. I will continue that bond, Mr. Smith, with the condition that you be back here, hopefully with your attorney. But you have to be back here by Zoom at that date and time given, January 13th, 2025, 9 a.m. Anything further, Mr. Regier?
No, Your Honor.
Mr. Smith, anything further?
No, Your Honor.
Thank you, sir. Then you are excused.
Thank you.
You're welcome. We will now be on the record in 2023 TR 2629, State of Kansas versus Ray Ann Starkey. Jared Regier appears for the state, and
Ray Ann
you
has
are
been
Ray
seated
Ann
cross-legged
Starkey,
on the
ma'am?
floor this whole time.
Yes, I am.
The defendant, Ms. Starkey, does appear in person and pro se. Looks like you appeared December 27, 23 before Judge Murphin presiding. No, he was here, but you failed to appear. I'm sorry, because apparently we didn't get service of the summons, and Mr. Regier asked to try again on his summons. But we came back March 25th, and we still couldn't reach you by summons, so they had to request a bench warrant, and that was granted with a bond set at $2,000 OR. I trust you posted that, Ms. Starkey?
Yes, ma'am.
And you were responsible and called to get the Zoom codes. Thank you. So let's look at your charges. You only have two. Count one is driving while suspended, a Class B misdemeanor. If convicted, $100 to $1,000 in fines and 6 months sentence are possible. Those are the maximums. Count two, operating a vehicle without registration or expired tag, an unclassified misdemeanor. The maximum fine could be up to $2,500. The sentence could be 30 days to 6 months, although probation and much lower amounts are often seen in those kinds of cases. Now, do you wish to look into diversion or hire an attorney, apply for court appointed, waive your attorney and represent yourself?
I would like to apply for diversion if I can.
All right, I will set this over to, what's that February date, Jen?
February 12th.
February 12th at 9 a.m. That is so far off that you have plenty of time to be diverted if you're serious about it. So make sure you get started on that right away. If you have any problems with it, contact the county attorney, of course, and I think you've taken down the website, the phone number, and all that.
I have.
And you're on the 2,000 OR bond, which I will continue with the added condition that you reappear February 12th at 9 a.m. unless your diversion is on file. If they've approved you and you've sent the contract and money back and they've filed it, you won't have to come see me again.
Okay.
So, Mr. Regier, anything further on this case?
No, Your Honor.
All right. Thank you, Ms. Starkey, and I do appreciate the fact that you've been stuck to the end of the docket. It's
Okay.
been a long morning for you. Thank you. All right.
Have a good day.
You too. You may go at this time. Thank you.
Bye-bye.
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 Okay, there's someone left named Norman. Might you be Norman Mitchell?
Norman, are you here?
I don't have a last name, but is there a Norman Mitchell?
Yes, ma'am.
Thank you, sir. We are on the record now in 2024 TR 1526, State of Kansas versus Norman Lewis Mitchell. Jared Regier for the state. Mr. Mitchell appearing in person and pro se. This is your first appearance, Mr. Mitchell, so I'll go over your charges. In count one, it is alleged by the state that you on January 6, 2024 in Butler County, Kansas, committed the crime of fleeing and eluding, that you failed or refused to bring a motor vehicle you were operating to a stop, or you otherwise did flee or attempt to flee a pursuing police vehicle or bicycle when given a visual or audible signal, to wit, a hand, voice, siren, or emergency light, and you didn't stop when given that information by a police officer in an official police vehicle or bicycle. This charge is a Class B non-person misdemeanor. The sentence could be up to 6 months. The fine could be up to $1,000. In count two, you're accused of operating without proof of insurance. If you had proof, get that to the county attorney and they can dismiss. If you didn't, the penalties could be at least $300 in fines, up to $1,000, and up to 6 months in jail. Count three, you're accused of speeding 70 miles per hour in a 50-mile-per-hour zone. That is a traffic infraction. It does not carry any jail time, but there is a scheduled fine. Do you want to look into diversion, hire an attorney?
Diversion is a solution
waive
that
attorney,
involves
represent
possibly
yourself.
classes, training, a different fine outside of
I would
court.
like to waive my attorney and represent myself, ma'am. Your Honor.
Did you want to look into diversion to see if you could get this charge or charges dismissed?
I mean, if it's going to stop me from getting it handled today, then yes, I want to get it taken care of today. Like, you know what I mean? I don't.
Well, diversion could not resolve it today. That would take a period of time. Your choice is today. Now, you can plead not guilty and set that over for trial, but that would be another day.
No, I wouldn't want to plead not guilty to no charge but the proof of insurance.
Okay, well, you also could plead guilty and admit the charges, or no contest, which means you don't want to admit the charges, but you don't want to plead not guilty and set them for trial either. Even though you're pleading not guilty, or even though you're pleading no contest, you'd still most likely be found guilty, though, proceed with sentencing.
Yes, Your Honor. I'd rather plead guilty to the two charges of the fleeing, eluding, and the speeding, I'd rather plead to those two and dismiss this insurance, because if I could have a minute of the court's time, I would like to explain a little bit what happened.
Well, that's what normally you would do at trial, because I can't dismiss the insurance except at trial. The county attorney can dismiss the insurance upon proof of insurance at the time you were stopped.
Yes, ma'am.
And they normally need you to give them written proof, and then they need time to contact the insurance company and verify that that written document is accurate. So to get that insurance dismissed, I think we're going to have to set it over. So is that okay? And since
so what's the possibilities? What's going on with? I'm just trying to get this behind me, honestly.
Well, I understand that, but you're looking at some pretty significant charges. Fleeing and eluding, no insurance, those are pretty big deals. So you might want to talk to an attorney that can give you advice and help you present your case. Would you want to do that?
Yes, ma'am.
Yes, that's right.
Okay, do you want to hire an attorney? You want to look into court appointed? You want to see if you qualify for court appointed?
Yes, I'm gonna try to get a court appointed. I'm in between jobs right now. When this happened, I lost my job.
All right, do you have any income at all?
No, ma'am.
How long have you been without your job?
6 months, 7 months.
Okay, no income? How do you get by? Does someone help you pay your bills, or?
Yes, ma'am. I got a partner.
Okay. And does that person live with you as well as pay the bills?
Yes, ma'am.
And what do they, how much do they make per month?
Honestly, they just lost their job, so they ain't
Uh-oh,
between
so
jobs.
you guys are in trouble.
Yeah, we're in
All
trouble
right.
big time.
Okay, I will appoint attorney Darren Patterson. Did you write down his name and number a while ago?
Yeah, he probably ain't gonna answer the phone. How many people calling him?
Well, he's got a contract. He's been doing it for, many, many years. He knows what he's doing, and he's got a good number of staff members that help him too. So don't worry about that. If he doesn't answer the first time, you can always call back, but keep trying. So it's Darren Patterson. And then do you need his number, or do you have that?
I have it.
Okay.
So what's the possibilities of us going through just the court right now today?
0 if you're wanting things dismissed. And
pleading guilty.
I'm saying if I just plead guilty to everything.
Well, first of all, your driver's license is going to be in serious jeopardy for 3 years.
Dang.
Yeah. So, and then the insurance is at least a $300 fine. The flee and elude, each flee and elude you get, you lose your license for some time over that. Now, you don't usually on the first, but you can on the second. So, all right, I will appoint Darren Patterson, and we will set this over to January 13th at 8 o'clock. Is that right, January 13th?
That is correct.
All right, you need to be back here by Zoom with Mr. Patterson, January 13, 2025 at 8 a.m. But call him as soon as this hearing is over and give him all your contact information, and then set up a time when he can give you some good instruction and advice so we can maybe resolve this January 13th if that's what you still want to do. You need to, I think you appear on a summons, so we're going to need to have you do an OR bond of $2,500. You don't have to put that money up unless you fail to come to court or fail to do what you're told. And part of what you're told is to contact Mr. Patterson as soon as this is over. And you'll need to go in a breakout room when it comes on your screen with court security too, and they'll help you get your bond made and picture and prints taken. So anything else, Mr. Regier, on this matter?
No, Your Honor.
Mr. Mitchell, anything further? Trustee just went in the breakout room. All right, thank you.
What was the OR bond?
OR, yes.
Bug Duggar, thank you for the 5 gifted memberships.
25. $2,500.
I did hear a tang, like that somebody got hit in the face with a frying pan sound. There's some clicking.
Let's go back to these failures to appear.
FTA.
On the record in 24 TR 2899, State of Kansas versus Candace Michelle Leach. Jared Regier for the state. The defendant fails to appear.
These are going to be pretty form.
Mr. Regier.
Pretty much bench warrants across the board, I'm
One
guessing.
moment, Your Honor.
Let's see if we've got some more, any excitement left in court, or if everyone's at lunch. Oops, sorry, I hit the wrong thing. Let's go back to her while he does that. Ouch. I completely dropped the remote.
An appearance bond had been executed back in August for an appearance on today's date and time of November 6, 2024 at 9 a.m. Professional surety for $1,000. Accordingly, the state is suggesting a bench warrant bond forfeiture 2,000 cash or surety would be appropriate.
That will be the order of court. Bond forfeiture bench warrant, 2,000 you said, cash or surety recommended?
That is the state's recommendation at this time, Your Honor.
That will be the court's order at this time. Being in recess.
All right, being in recess on that one, we're going to go on to something else, which specifically is going to be back to Judge Cedric Simpson just for a little bit. As we... Judge Cedric Simpson. There we go. And he just barely... Seriously? Like he was live just a minute ago and then he went on break. Maybe it's time for lunch. I think it's time for lunch. I will tell you that I tried to make my chair squeak less than it currently does, because it's... Yeah. I tightened everything. I have not doused it in WD-40 yet, but that's the next move. Valerie, did you cover Sarah Boone wanting a new trial? We did. We went over that document, the reasons why she thinks that a mistrial is appropriate in her case and a new trial. We also covered Brian Kohberger's documents saying he doesn't want death penalty on the table. Sorry, this is in the way. He wants death penalty off the table for his trial. He also wants to trifurcate, not bifurcate, but trifurcate his trial. He has a hearing tomorrow, which we'll be watching live, Brian Kohberger. Part of it may be closed because we know there's at least a motion for discovery that will be sealed. So part of it might be closed. WD-40 will clear that squeaker. I just don't know where the squeak comes from. I mean, it only squeaks when I'm sitting on it and move. And I don't want to spray the pleather. Blaster silicone lubricant instead of WD-40. I only have WD-40, unfortunately, Adam. No squeaky springs. I retightened the base. Hey, you making me lunch? Is that what you said? No. My daughter's not making me lunch. All right, I think we are ready for lunch. When we come back, we might have some more Judge Simpson. I have not seen Judge Wolf in a few days. Judge Stephanie Boyd has also been noticeably absent the last couple of days as well. A couple of our favorites have not been around, but we'll keep an eye out for what's coming up, as well as some new court cases we're looking into. We've covered the Karen Reed thing this morning. Just as a summary, with Karen Reed, argument before the Supreme Court in PA. The Supreme Court, the state Supreme Court, not national Supreme Court, not federal. The strong arguments made, rough questioning on both parts, for both the state and for the defense, as to why they think it should be considered that the jury reached a conclusion, or why they think it should not be considered the jury reached a conclusion of not guilty on the first 2 counts. So if the Supreme Court rules that the lower decision stays, she will be tried on all 3 counts again, and they will say that's not double jeopardy because the jury never actually made a formal finding. If they find that the jury did reach that finding, they will be basically creating new law. It will be case law, but it will be creating new law in Pennsylvania, because this is no man's land. We don't have anything prior to this that really spells out how they should act. So it'll be interesting to watch. Might be a few weeks before they get a response on that one. Anyway, tonight before you go home, please, or tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe until we go live again after lunch with a little more court hopping as we get set for our next trial. Appreciate y'all. We'll see you after lunch. Have a good one. Bye-bye.